You got a bunch of people out there, Ronnie? Okay. All right. Well, good morning, everyone. In a minute, we're going to go ahead and start taking open announcements on the 9 a.m. docket. I don't think we have anybody on Zoom for me to talk to. So for those in the courtroom, if you want to wear a mask, wear a mask. If you don't want to wear a mask, don't wear a mask. It's not my job to make decisions on your personal health. I do require the inmates to wear a mask, and that's for a favor for the sheriff. But other than that, the first thing I'm going to do is I'm going to call the names of those who are going to go take a drug test. If you hear your name called, you will take a drug test today. You'll go with probation. You'll take the test. When you get done, you'll come back in the courtroom and we'll go over the results together. And so with that, is there a Brandon Collins? All right, sir, you're going to take a drug test this morning. Cheryl Franco. All right, I'll go through these again in a minute. Michelle Ortiz. Cortez Cooper. Manuel Garcia. Okay, got it. Shelly Riggins. So Shelly Riggins. I have 3 files here. Haley Skaggs. Stephen Henderson. No Stephen Henderson?
Mr. Morrison.
Trey Walters. Jessica Flatt. Okay. Timothy Campbell. Scotty Barker. Custody?
Yes, sir.
Matthew Poe. Man,
He's on Zoom.
he's on Zoom. Why is he on Zoom?
He's talking, so he was sick.
Tony McLean.
The waiver was filed on that.
Amy Bookman.
Waiver,
Penny Buckley.
she was arrested this morning.
Robert Chapman.
He is in Smith County.
Why are we filling all these? Okay. Terry McCleskey. Guess nobody wants to come to court this morning. Nope. Raymond Morgan. Gregory Morrison. Aha, you're going to take a drug test this morning, sir. You'll go with probation. Take the test. When you get done, come back in. We'll go over the results together. Cassie Presswood. Jack Riskin. And finally, Garrett Warren. Mr. Warren, you're going to go take a drug test. When you get done, come back in the courtroom. We'll go over the results together. So what I'm going to do is I'll start taking open announcements, and then we'll go through the docket, and those that aren't here, the court will entertain a motion. These, can you just get those? So those are not ones that I need to sign. Those are people that are either in jail or you took off. These are the people that are not here. Let me sign these. If that's for me, just tell them I'm on the bench and I'll call them back later. I'm busy. Why is he not? Yes, sir. Okay. Did I give you my docket? All right, well, we'll wait for him to get done. I didn't? Here it is. Mr. Mills.
Robert Graham in custody.
Robert Graham. Come on up, sir. This is cause number CR 21-0321-392, the state of Texas versus Robert Graham. Set for arraignment, Mr. Mills.
Judge, I've received a copy of both indictments. His name is spelled correctly in both the indictments. He understands what he's been charged with. We'll waive formal reading of both indictments and enter pleas of not guilty to both charges.
All right, Mr. Graham, the court notes your plea of not guilty. Was there another one? Did I miss it? Yes, I did. Also cause number CR 21-0320-392. So the court notes your pleas of not guilty in each case. Your two next court dates are July the 7th at 1:30 for discovery status, and then again on August the 4th at 1:30 for pretrial. So if you get out of jail between now and then, I need to see you back here on July 7th.
Yes, sir.
Okay, sir?
Yes,
All
sir.
right, thank you.
Thank you.
Judge, I had some others that I don't know. I don't think they're here. The court wants to go ahead and call them.
Yep.
Shelley Riggins.
Shelley Riggins, is that one that you took off? No, okay. All right, cause number CR 21-0386-392, state of Texas versus Shelley Riggins. Is there a Shelley Riggins in the courtroom? I see no one. I hear no answer. There's not a Shelley Riggins appearing via Zoom. She is not in the lobby. The time is now 9:08. The docket was for 9 a.m. The court will entertain a motion.
Judge, state request bond forfeiture in this cause.
Granted, capious issues shall be held with no bond, and I'm here all day if you find it.
Yes, sir.
Yeah, I see that. Haley Skaggs.
Yes, sir.
Haley Skaggs. Cause number CR 21-0211-392, state of Texas versus Haley Skaggs. All right. Is there a Haley Skaggs in the courtroom? I see no one. I hear no answer. There's not a Haley Skaggs appearing via Zoom. The time is, her name was called. She's not in the lobby. The time is now 9:09. Docket is for 9 a.m. Court will entertain a motion.
State request bond forfeiture in this cause.
Granted, capious issues shall be held with no bond.
I had a Cortez Cooper on there, but he may be in TDC somewhere.
Yeah, I think I called that one. He said he was in TDC.
That's all. I have one more. He's being drug tested, so.
Okay.
We need to reset. Mr. Cooper. For arraignment.
What page?
TDC page 2. 6-3 and 9 o'clock.
What about Michelle Ortiz? Did we do a bench warrant?
It was requested, but it was issued.
So we were,
Both of them were requested.
all right, so state CR 21-0126-392. Ms. Thompson. Thank you. State of Texas versus Michelle Ortiz. Y'all need to issue a bench warrant for that and I'll sign it. Get me one. And I'm resetting that to June 3rd at 9 a.m. And then also CR 21-0198-392, the state of Texas versus Cortez Cooper. Also, they're in TDCJ. I'm resetting that to June 3rd at 9 a.m. And if y'all prepare a bench warrant on that one, I'll sign it. All right, continuing on with 9 a.m. Mr. Harrington.
Yes, sir. Page 2, Chelsea Duncan for arraignment.
Chelsea Duncan. CR 21-0369-392, the state of Texas versus Chelsea Duncan. Is there a Chelsea Duncan in the courtroom? I see no one, I hear no answer. There's not a Chelsea Duncan appearing via Zoom. She is not in the lobby. The time is now 9:11. The docket was set for 9 a.m. The court will entertain a motion.
Thank you, Judge. State request line forfeiture.
Granted, capious will issue, shall be held with no bond. Next one, Mr.
Jackson, Frederico Jackson, right below that.
Frederico Jackson.
Or in this case, I think,
I'm sorry.
my understanding, he was in the Dallas County Jail. Henderson County put a hold on this case on him. Apparently, he bonded out of there on this warrant on April 3rd. 2021. But I don't think the bail bond's been filed with this court yet, I believe.
Did he even get notice? Okay. I'm going to reset it for June 3rd at 9 a.m.
That just maybe it's used.
Yes, sir. Appreciate you. Yes, sir.
Timothy Campbell, and then for Bill Stevens. I don't believe he's here.
This is cause number CR 21-0363-392, the state of Texas versus Timothy Campbell. Set for arraignment. Is there a Timothy Campbell in the courtroom? See no one, I hear no answer. There is not a Timothy Campbell appearing via Zoom. Timothy Campbell's not in the lobby. Time is now 9:13. Docket was set for 9 a.m. Court will entertain a motion.
State request line forfeiture.
Granted, capious will issue, he'll be held with no bond.
We're sending notice to his address on his bond.
Robert Anderson, Your Honor.
Robert Anderson. All right, these are cause numbers CR 21-0133, 34, 35, and 36-392, all styled the state of Texas versus Robert Anderson, and all set for arraignment. Mr. Stevens.
Your Honor, for purpose of arraignment, his name is spelled correctly on all the indictments. He understands the nature of the charges against him, waives formal reading of the indictments, and enters pleas of not guilty to all of the cases set for arraignment.
All right, Mr. Anderson, the court notes your pleas of not guilty. I'm going to reset all these cases first to July the 7th at 1:30 for discovery status, and then again on August the 4th at 1:30 for pretrial. So if you do get out of jail between now and July, I need to see you here on July 7th at 1:30. Okay, sir.
I'll give him his reset notes here just a second, Your Honor. Gary Connor.
Gary Connor. All right, this is cause number CR 21-0317-392, the state of Texas versus Gary Connor, set for arraignment. Mr. Stevens.
Your Honor, for purpose of arraignment, his name is spelled correctly on the indictment, understands the nature of the charges against him, waives formal reading of the indictment, enters a plea of not guilty.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. You're going to receive 2 new court dates there in writing. The first is for July the 7th at 1:30 for discovery status, and then again on August the 4th at 1:30 for pretrial. So if you get out of jail between now and then, I need to see you back here on July 7th at 1:30. Thank you, sir. As soon as you receive your reset notice, you can have a seat.
Christopher Bridges.
Christopher Bridges.
And Your Honor, he is not going to be present. I just received looks like a printout of a text message that his father had some kind of incident. He had to fly to North Carolina for an emergency. If I'd have known earlier, I would have asked the court for permission to appear by Zoom. I was gonna see if maybe we could have some leave of court, see if I can track him down and maybe this afternoon do his arraignment by Zoom. Or if the court will allow me to file a waiver of arraignment.
Well, I mean, when did he fly out?
The message just says that I just got to North Carolina this morning. My dad had a spell. It was an emergency. Can I put in a reschedule for a court appointment? They sent it to the bondsman and then the bondsman, I guess, delivered this to the court this morning.
Yeah. I'm gonna call it CR 21-0379-392, the state of Texas versus Christopher Bridges. Sir Christopher Bridges. All right, Christopher Bridges. I hear no one. I see no answer. There's no answer, or Mr. Bridges is not appearing via Zoom. The time is now 9:17. The docket was for 9 a.m. The court will entertain a motion. Granted, KP so issue, he'll be held with no bond. And if you get more information, just
Yes,
let me know.
And that,
I got to treat him like everybody else.
yes, sir. And that concludes my business, maybe?
Yes, sir.
Thank you.
Ms. Moore.
Page 5, Jason Paul White.
Jason White. This is cause number CR, we got somebody here, CR 21-0364-392, the state of Texas versus Jason White. And set for arraignment, Ms. Moore.
Your Honor, this is Jason Paul White. His name is spelled correctly in the indictment. He understands what he's charged with. As set forth in the indictment, would enter a plea of not guilty for purposes of arraignment and not true to the enhancement paragraph.
All right, sir, the court notes your plea of not guilty and not true for purposes of arraignment. Your next two court dates are July the 7th at 1:30 for discovery status. And then again on August the 4th at 1:30 for pretrial. So as soon as you receive your reset notice, you're free to go. Stay in touch with your bondsman and your attorney. Okay, Mr. White? Yes, sir.
And Danielle Cullifer. It should not be the page before.
Danielle Cullifer. All right, this is cause number CR 21-0059-392, the state of Texas versus Danielle Cullifer, set for discovery status.
And Your Honor, yes, her case was on your afternoon docket yesterday, and she was not here until late in the day. And I asked her to please be here first thing in the morning to try to ask the court to please set aside her bond forfeiture. It was a mistake on her part that she wasn't here.
You know, I got to treat her like everybody else. Did we, well, let's hold the discovery status.
She here, she was on.
She was not
She
here.
wasn't here
I forfeited
yesterday.
her bond yesterday.
Yeah, she came later in the day. And court was already over.
We
and-
were here till,
She showed up, she called from the outside phone, and I talked to her, it was about 4:30. You know, everybody was gonna- we finished briefing. I told her to contact her.
Which she did, and I asked her to show up today, and
well, she received notice in open court. So here's what or was she a waiver?
she was a waiver of her arraignment.
Okay, here's what I'm gonna do. I'm gonna order to, based upon your appearance and demeanor, I'm gonna order you to take a drug test today. You'll go take that drug test. Do not leave. Come back in here and we'll go over the results together, and the results of that drug test will help guide the court in its decision. Can we hold discovery status though while she's here? That way we don't have to hold it.
Yes.
Discovery.
Discovery was provided to the defense. There were two offers made. One was for probation and one was for jail time.
Any discovery issues, Ms. Moore?
No, not that I'm aware of. I think we've gotten everything, and I've conveyed the offer to Ms. Cullifer.
Okay, Ms. Cullifer, go ahead and take that drug test and we'll go over the results later. Don't leave.
And then I have Trey Walters. He was, I think he may want him to go take a
Trey
drug test.
Walters.
Yes, I don't think he was here a minute ago when you were ordering.
Trey Walters. Did I already sign an order on him?
I'm sorry.
Did I sign an order on him?
He wasn't here when you called.
He wasn't
Okay.
here. Did I guess I didn't issue a case yet.
Not yet. We didn't.
This is cause number CR 21-0094-392, the state of Texas versus Trey Walters, and set for arraignment, Ms. Moore.
This is Trey Daniel Walters. He is the same person charged in the indictment. He understands what he's charged with is set forth in the indictment. We would enter a plea of not guilty for purposes of arraignment and not true for the enhancement paragraph.
All right, sir, the court notes your plea of not guilty and for purposes and not true for purposes of arraignment. You're going to receive 2 new court dates there in writing. That's July the 7th at 1:30 for discovery status. And then again on August the 4th at 1:30 for pretrial. And I'll just tell you, sir, I called your name at 9 o'clock. And I don't know whether you got mixed up on where you're supposed to be, but it's 2 things you don't want to be late for, your wedding and felony court. So if you're not 15 minutes early, consider yourself late, because I'm going to call the docket right at 9, okay?
Yes, sir.
All right, but I'm ordering you to take a drug test today. I'm gonna let you slide on being late today, but don't let it happen again,
Yes, sir.
please. There's a lot of people trying to get work done, and when people are late, it just messes up the whole system. But I'm ordering you to take a drug test. You'll go take the test. When you get done, come back in the courtroom and we'll go over the results together. Thank you, sir. Yes, sir. Ms. Thompson.
Hey, Jay, Jonathan Arnold.
Jonathan Arnold. This is cause number CR 21-0370. Mr. Arnold, can you take those sunglasses off the back of your head? You're in court. Thank you. CR 21-0370-392, the state of Texas versus Jonathan Arnold, and set for arraignment, Ms. Thompson.
Your Honor, I was just appointed this morning on him. We have gotten a copy of the indictment. For the record, his first name is misspelled. It's JOHNOTHN. The rest of it-
THN or THAN?
THAN,
Can I see the indictment?
but it's JOHNOTHAN.
All right, does anyone mind if I amend and interlineate the indictment to correct spelling of the name?
No objection, Your Honor.
We'd agree to that, Judge.
All right, well, then I'm changing it here on the heading and in the substance of the indictment.
Notice he does understand what he's charged with. For purpose of today's hearing, we need a plea of not guilty and waive the reading of any formal indictments.
All right, Mr. Arnold, the court notes your plea of not guilty for purposes of arraignment. You're going to receive 2 new court dates there in writing. That is July the 7th at 1:30 for discovery status, and then again on August the 4th at 1:30 for pretrial. However, based upon your appearance and demeanor in court this morning, I'm going to order you to take a drug test. You're going to go take a test. When you get done, come back in the courtroom and we'll go over the results together. Thank you, sir. I need an order on him. Thank you, sir. It'll catch up with you. Yes, sir. Who else you got? Thank you, sir. Thank you. Ms. Thompson.
Yes, sir. Scotty Barker, Your Honor, page 7. Maybe page 8. No, it's page 7, Your Honor.
All right, this is cause number CR 21-0375 and 0376-392, both style, the state of Texas versus Scotty Barker, and both set for arraignment. Ms. Thompson.
Your Honor, we have received copies of the indictment. His names are spelled correctly on both. He does understand his charges. For purpose of today's hearing, waive the pleas of not guilty, waive the reading of any formal indictment, Your Honor.
All right, Mr. Barker, then the court notes your plea of not guilty to each of these cases for purposes of arraignment. You're going to receive 2 new court dates there in writing. It is July the 7th at 1:30 for discovery status. And then again on August 4th at 1:30 for pretrial. And so as soon as you receive those, sir, you can have a seat. And if you get out of jail between now and July, I need to see you here on July 7th at 1:30.
Your Honor, we're also here for the purposes of motion for bond reduction.
Oh, I see it on there now. Okay. And all right. And are we going to hear testimony from your client for the limited purpose of bail?
We are, Your Honor.
All right, Mr. Barker, if you can pull that down for me. All right, there you go. And raise your right hand the best you can. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Now you can lower your hand, Ms. Thompson.
Can you state the full name for the record?
Scotty Lamont Barker.
Okay, Mr. Barker, you understand we're just doing a bond reduction here right now, is
Yes,
correct?
ma'am.
Okay. Are you asking this court to consider you for a PR bond on this charge?
Yes, ma'am, I am.
And then, where do you live at?
Well, I was staying at 309 Barker Street
Where you used to live, where do you live at now?
in Henderson County Jail.
And then, okay, all right. Do you have a home to return to should this court decide to release your bond?
Should I what?
Do you have an address to return to?
Yes, ma'am, I do.
Okay, where would that be
It'd
at?
be 203 St. Joseph Street,
And where's that, what city?
Athens, Texas.
Okay. And who is at that residence?
That's my Amy.
Okay, all right. And do you have a phone number there that where you could be reached?
Yes, ma'am, I do, but I don't know it,
Okay,
but I will get it to the court.
okay. Do you own a vehicle of any kind?
No, ma'am, I don't.
Okay. Do you have a job?
No, ma'am, but I ain't a problem. I can get a job.
Okay, but you don't have a job at this time, is that correct? Have you got any friends or family that could help you meet the bond is what it currently said at 15,000?
No, ma'am, I don't.
And the state offered to reduce your bond to 10,000 this morning, is that correct?
Yes, ma'am.
And you said that that would not assist you because you could not make that bond still,
Yes,
is
ma'am.
that correct? So you're asking for the court to go ahead and give you a PR bond, is that
Yes,
correct?
ma'am.
And you're telling this court that if they give you a PR bond, that you'll report to probation as required?
Yes,
You
ma'am.
will appear for all settings and all areas, is
Yes,
that
ma'am.
correct?
Yes, ma'am, that's correct.
Okay.
Hello.
Pass the witness, Sean.
Mr. Barker, you said that you don't have a vehicle,
No, sir, I don't.
but you also said that you plan on coming to court and showing up to pretrial.
I stay right down the street.
About how far?
St. Joseph. I was in the 309 Barker Street, north of here. And then, but by 80, where mommy staying with her.
So are you saying that you're gonna walk?
It's just walking distance,
About how long in length?
about 10 minutes.
No further questions for this.
It's 10 minutes away, sir.
Nothing further.
Anything else? Any other witnesses?
No other witnesses, Your Honor.
State?
No witnesses, Your Honor.
Okay.
I would ask to be heard on. Close. Your Honor, if I could, we're going to agree to a PR bond on your case. The state was not ready within 90 days. On the,
He's entitled to a PR bond on that one.
yes. We'd ask that the bond stay the same on the theft case at 15,000. Mr. Barker has previous convictions for assault, 4 times for burglary of a vehicle, burglary of a habitation, theft misdemeanor, theft felony, burglary of a vehicle felony, theft misdemeanor, criminal trespass, and theft felony.
I think that bond is very reasonable for his criminal history.
Yes.
And so the court then, by law, he's entitled to a PR bond. It's been 90 days. So on the possession case, the court is granting the motion to reduce bond to a PR bond. And I'm trying to find, you only gave me one order for both.
Yes,
What is his bond on the PCS?
it's,
It's a 20,000 on the, it's a $20,000 bond with your case. So
All right,
that's
well,
where-
then I'm going to grant that request. It'll be $20,000 PR, personal cognizance bond. And then on the, was that a theft?
Yes, on the first one, it was 15,000 and it remained the same on the indictment.
Okay, and so on that, then the bond will remain at $15,000 surety bond. I'm gonna have to get creative on writing in this order here, so give me just a moment.
Thank you, Your Honor.
Thank you, John.
Your Honor, I have one case left.
Yes, ma'am.
It will be by Zoom, I'm assuming.
I didn't know we had someone appearing, a defendant appearing via Zoom.
I didn't understand you, Your Honor.
I said, I didn't know we had, did this get pre?
She told me about it. So
Okay.
Mr. Cole was under the way.
No.
It's a $1,500 bill. Check in, check out.
All right. Here's that order. This is, which case is this? So Matthew Poe, sorry. Mr. Poe, can you see and hear me? Do me a favor, if you'll turn your video off, because you looks like you have low bandwidth, I might be able to hear you better. Can you hear me?
Can you hear me now? Yes,
Yeah, I
sir.
got you a little better. All right, and I'm gonna call your case for arraignment then. These are cause numbers CR 21-0355 and 0356-392, both styled the state of Texas versus Matthew Poe, and both set for arraignment. Ms. Thompson.
Your Honor, I just got the indictments this morning. Mr. Poe has not seen them.
All right, the state present the indictments, please.
Thank you, brother.
And if you could step up in the camera view so he can also see you. He should have you now. I've got you.
You got me?
Well, yeah,
Maybe.
I can see you. I can see that screen.
All right, we'll start with CR 21. Mr. Poe, can you hear me?
Yes, sir.
CR 21-0355-392, State of Texas versus Matthew Timothy Poe. Matthew spelled Matthew, Timothy Timothy, Poe, Poe. You're charged with possession of controlled substance, penalty group 1 less than 1 gram, a state jail felony, enhanced punishment 2 to 10. In the name and by the authority of the state of Texas, the grand jury for the county of Henderson, state of Texas, duly selected, impaneled, sworn, charged, and organized as such at the January term 2021 of the 173rd Judicial District Court for said county, upon their oaths present in and to said court at said term that Matthew Timothy Poe, hereinafter styled defendant, on or about the 18th day of June 2019, and before the presentment of this indictment in the county and state aforesaid, did then and intentionally or knowingly possess a controlled substance, namely cocaine, in an amount of less than 1 gram, with 2 enhancement paragraphs. Enhancement paragraph 1, and it is further presented that prior to the commission of the charged offense, hereinafter styled the primary offense, on the 26th day of June 2013, in cause number A-17949. In the 173rd District Court of Henderson County, Texas, the defendant was finally convicted of the felony offense of possession of a controlled substance. And it is further presented that prior to the commission of the primary offense, on the 20th day of June 2015, in cause number CR 15-00319, in the 294th District Court of Van Zant County, Texas, the defendant was finally convicted of the felony offense of possession of a controlled substance against the peace and dignity of the state, signed by the 4 persons of the grand jury.
And Ms. Thompson, as to the underlying charge, how does your client plead guilty or not guilty?
Your Honor, we plead not guilty at this time.
And how does he plead to
not-
the enhancement paragraphs? True or not true?
Not true, sir.
All right. All right. And then if you'll present the next indictment.
Your Honor, could we interlineate by motion, did
Then and there.
then and there? It's just extra language, but any objection to that?
No, I have no objection to that.
All right. Well, then without objection in the court, in the body of the indictment is inserting a there between then, I'm sorry, between and intentionally. So it'll read did then and there intentionally or knowingly.
Thank
All right,
This is
Mr.
Nathan
Poe, listen
Alfred.
up. He's going to present the next indictment.
Yes, sir.
Mr. Poe, CR 21-0356-392, State of Texas versus Matthew Timothy Poe, spelled the same way as CR 21-0355. Charge tampering or fabricating physical evidence with intent to impair. Third-degree felony with a 2 to 20 punishment range. In the name and by the authority of the state of Texas, the grand jury for the county of Henderson, state of Texas, duly selected, empaneled, sworn, charged, and organized as such at the January term 2021 of the 173rd Judicial District Court for said county, upon their oaths present in and to said court at said term, that Matthew Timothy Poe, hereinafter styled defendant, on or about the 18th day of June 2019, and before the presentment of this indictment in the county and state aforesaid, did then and there, knowing that an investigation was pending or in progress, namely an arrest for a felony warrant, intentionally or knowingly alter or conceal a thing, namely methamphetamine, with intent to impair its verity or legibility or availability as evidence in the investigation. Enhancement paragraph, and it is further presented that prior to the commission of the charged offense, hereafter styled the primary offense, on the 26th day of June 2013, and cause number A-18566 in the 173rd Judicial District Court of Henderson County, Texas, the defendant was finally convicted of the felony offense of prohibited weapon against the peace and dignity of the state, signed by the foreperson of the grand jury.
Ms. Thompson?
Not guilty, Your Honor, and not true as to the enhancement paragraph.
All right, Mr. Poe, the court notes your pleas of not guilty to each of these cases, as well as not true to the enhancement paragraphs alleged. You're going to receive, or I'm giving you 2 new court dates. That is July the 7th at 1:30 for discovery status, and then again on August the 4th at 1:30 for pretrial. However,
sir.
now we need to deal with the issue of why you're not here in court. And so, Ms. Thompson,
Your Honor, Mr. Pro contacted me yesterday at my office and told me that he was very ill and did not think that he should come to court this morning. He needed to go see a doctor, and informed me he was going to see a doctor once he got off the phone with me.
okay,
I have not received any paperwork or anything from him that shows that he did that.
I'm needing her email to send her the paperwork.
well, I'm not going to have him testify unless I swear him in. I mean, are you going to ask him any questions?
Yes, sir, go ahead.
All right, and Mr. Poe, I'm only going to allow questioning for the limited purposes of why you're not in court this morning after you've been told to be. So if you'll raise your right hand, let me know when it's raised.
I got it. Yes, sir.
All right, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your
Okay.
hands. Ms. Thompson?
Mr. Poe, did you call my office?
ma'am.
Did you call my office yesterday and advise me that you could be in court today because you were sick?
Yes, ma'am.
Did you also state that you were going to go see a physician?
Yes, ma'am.
Did you go see a doctor or go to the emergency room?
Yes, ma'am.
Okay, and what was the diagnosis?
They what was it? They told me that I had a strep throat, and possibly the flu. And they sent me home with some medicine.
Did you get any paperwork to show that?
Yes, ma'am.
And did you, I don't know, did you say you had emailed it or you needed to email that
I
information?
need your email so I can send it to you.
Well, we can do that off of this, so.
Are you running any kind of fever, Mr. Poe?
Yes, ma'am.
What kind of fever do you have?
101.
Pass the witness, Sean.
No questions, Your Honor.
All right, Mr. Poe,
Yes, sir.
I'm going to go ahead and accept the fact that you did go to the doctor and you appeared via Zoom.
Yes, sir.
However, only because you don't have COVID, apparently, I would assume they tested you. Did they test you?
Yes, sir.
And were you negative?
They said, yeah, they get the test results back in 2 weeks. So they told me.
All right, but Mr. Poe, you do have a warrant for the new case that you were indicted on. I would assume it's that tampering with evidence. It looks like the grand jury indicted you on an additional charge.
Yeah.
And so I'm going to order you on, what's today, Thursday? I'm going to order you to report to the jail to turn yourself in no later than 5 p.m. on Monday, May. What day is that?
It should be over.
5 p.m. Monday, May 10th, to turn yourself in to the Henderson County Jail. Now, it looks like you already have a PR bond set, but you need to do a bookend. Is that correct?
Yeah, I'll just do some quick work. and get to the-
All right, so you're going to do that. And then when you're finished with that, on Tuesday morning at 9 a.m., and
Yes,
that is the 11th, you're going to report to probation for a drug test.
yes, sir.
All right, can you repeat those dates back to me, please, sir?
May the 10th, 4-5. I got to report to the jail, turn myself in.
Yes, sir. And there's already a PR bond. You just need to go in there and report. And
Yes,
then what else you need to do?
Tuesday morning, I need to go to the probation office and take a drug test.
Okay. And then your two new court dates then are July 7th and August the 4th at 1:30. And just give Ms. Thompson a call here in a little while and y'all can get that email address worked out. And I hope you get to feeling better.
Thank you, sir.
All right. You can log off now, sir. Thank you.
All right, thank you.
Yeah, that's all I had this morning. That excuse.
Thank you. Mr. Harrington.
As I was leaving, Frederico Jackson actually appeared. He was the one that didn't have notice, but he's present for arraignment if the court wants to do that.
Okay, he didn't. So he is here, but that's one we didn't get notice to.
Yes, sir. He was the one that found out the Dallas County Jail.
I got you.
He's present if you want to go arraignment.
Yep. You can bring him on up. That's Frederico. All right. This is cause number CR 19-0491-392, the state of Texas versus Frederico Jackson, and that is set for arraignment. Mr. Harrington.
Your Honor, Mr. Jackson has reviewed the indictment. His name misspelled correctly. He understands the charges, waive the formal reading, and plea of not guilty for the purpose of arraignment.
All right, sir, the court, I'm sorry.
And waive the formal reading of it.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. Your two next court dates are July the 7th at 1:30 for discovery status. And then again on August the 4th at 1:30 for pretrial. And so you're going to receive those in writing. To stay in touch with Mr. Harrington and the bondsman. We'll see you in July.
Thank you.
Yes, sir. Mr. Mills. Oh, yes, sir, Mr. Harrison. Which page is it?
Brandon Collins, first page.
Okay. Well, I don't have any. Brandon Collins, I got you.
Yes, sir.
All right, this is cause number CR 21-0322-392, the state of Texas versus Brandon Collins, set for arraignment. Mr. Harrison.
Your Honor, we've received a copy of the indictment. Mr. Collins' name is set forth correctly. He understands the nature of the charges against him, and we would enter pleas of not guilty in these cases.
All right, sir, the court notes you plead of not guilty for purposes of arraignment. You're going to receive two new court dates there in writing. That is July the 7th at 1:30 for discovery status. And then again on August the 4th at 1:30 for pretrial. And I also saw that you did test negative. Does he have any DWI conditions of bond?
No, sir.
It's not a condition. We have conditions here. Rich.
May I see them?
Yes, sir. I thought he had conditions with Mr. Hall. Was that pre-trial?
Well, he's been doing things voluntarily. that we talked with Mark about.
What did you and Mr., because the one that I have here that you just presented me is abstain from alcohol, illegal or controlled substances not prescribed.
He'll have to have an ignition interlock,
Right.
and he'll also have to not operate a vehicle without an ignition.
He's got that.
Okay. It's intox manslaughter, and I can't remember what DPS does.
Those are required.
Right.
Those were installed back in November.
All right, so Mr. Collins, I'm going to go over these conditions of bond again. You're to abstain from using any alcohol, illegal drugs, or controlled substances that are not prescribed, and also no marijuana. And I have to say now, including THC, gummies, whatever it is, none of that. And you also shall not operate any motor vehicle unless it is equipped, unless it is equipped with a device that uses deep lung analysis to make impractical the operation of that motor vehicle if alcohol is detected in the breath. And so I am signing these. I'll give that to you. And again, stay in touch with your bondsman and Mr. Harrison.
Yes.
These were, hold on.
I thought
That we already do have bond conditions. So all those do is just are
kind
a
of,
duplicate, but those are more. And those were already placed on him, I guess, whoever set. Did I do those?
No, he got it, I think.
Those were set by Judge Calhoun.
I think it was prior indictment. I'm not sure. It was ordered on April 12th, so it was after that.
So it would have been me. All right, so I think those just duplicate what I've already signed with more.
do we want these ones? I think these were made through Mr. Files and Mr. Hall.
That's fine. I guess that wasn't agreed.
It's just a copy.
And so I'm just going to refer to it on the record that the agreed bond conditions dated April the 12th are your bond conditions, Mr. Collins. If you have any questions about those, you can talk to probation or your attorney. Well, it was Judge Calhoun.
Okay, are these, is this for the defendant or is this your copy?
You can give it to the defendant.
We can give it to the defendant.
There's actually another copy in here.
That's off the record. There's
I thought I just missed the file.
also. That it?
Yes, sir.
Anything else? All right, good to see you.
Thank you.
Take care. Did he get his reset?
No, not yet.
Rants are always great. Mr. Castleberry.
Yes, Your Honor. On page one, I have Garrett Warren.
Did he already go take a drug test?
That'll be for arraignment, Judge.
Did he already go take a drug test?
Yes, sir. This is fine. Yes, sir.
All right, this is cause number CR 21-0327-392, the state of Texas versus Garrett Warren. And this is set for arraignment today. Mr. Castleberry.
Your Honor, we have received a copy of the indictment and we're going to waive reading this morning. And his name is spelled correctly and he understands what he's charged with and the range of punishment. And for purposes of arraignment, we're going to plead not guilty.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. You're going to receive 2 new court dates there in writing. That is July the 7th at 1:30 for discovery status. And then again on August the 4th at 1:30 for pretrial. And so as soon as you receive your reset notice, sir, also, it appears as though I ordered you to take a drug test based upon the nature of your charge. You have tested positive for methamphetamine and amphetamine. And it appears as though you admitted to probation that yesterday, Cinco de Mayo, yep, and you admitted to smoking meth. And so odds are you're probably still under the influence right now. Sir, you're on bond for PCS. And so I'm going to place conditions of bond on you. No alcohol, no controlled substances that are not prescribed, no illegal substances, no marijuana, including anything that has THC in it. Do you understand? All right, and so once you receive that signed conditions of bond by me in your reset notice, you're free to go. I will test you again in July, or I'm sorry, yes, in July when you come back. And if you test positive, I can't promise you you'll go out that door. You may go out that one. That one leads to the jail. Do you understand?
Yes, sir.
If you need help, ask. Lots of help out there. There you go. I'll see you in July, sir. All right, I'm gonna handle some of these folks. I got people on Zoom that have come in. Is it Mr. Howard?
Yes, hi, Your Honor. Good morning.
Morning. Who do you have?
I have Shelley Riggins, and I know that we just entered in an appearance yesterday. I sent in the notice, so appearance of counsel. I didn't even know James Mill was a court-appointed attorney for her until I was e-filing everything. And so that was, and I didn't, so I sent all that yesterday. I sent a motion for continuance. I sent a motion for substitution of counsel, all that yesterday. And so I haven't spoken with Mr. Mills. According to my client, she called him a number of times and couldn't get him. So she was, I think she was attempting, and she's on here. The reason why she isn't there today, and I apologize for that, is because my paralegal who's on the Zoom today with us, Jason Armstrong, talked to the district attorney's office yesterday about today. We didn't know this was happening yesterday, so we got everything filed. He called the assistant or the district attorney's office, and he's here to tell you about it. But he was told then that this would all be on Zoom, and so that we didn't know what else to do other than tell our client it was going to be on Zoom, and so that's what we informed her. So we didn't have that connection till after 9 o'clock this morning. And that's why we're all here, because I asked her, I said, well, how far? I have no idea how far she lives from the courthouse. Do you have a way to the courthouse? And I've been texting her while you were talking to the other defendants and the lawyers, and her husband's already left for work and she has no way to get down there anyway. We would have already signed the waiver of arraignment, but since I wasn't substituted in yet, I didn't know if the court recognized me as her attorney. I wanted to talk to you.
Well, I do see that she's appeared via Zoom. I don't need to hear testimony, but I will. I guess there was a motion for continuance filed.
Yes, Your Honor.
Okay. Well, let's do this. Let's go ahead and arraign her. Ms. Riggins, let me get her in here. Can you hear us?
Just unmute yourself, Shelley. She's not real familiar with it. That's on your computer on the bottom left-hand corner of your window. If you'll put your cursor over there where it says mute, and it has a little red line over it, just click it once, and we'll be able to hear you. Yeah, the left-hand corner.
I'll tell you what, as long as she can hear me.
Right.
Ms. Riggins, can you hear me? Just give me a thumbs up.
Yeah, nod your head.
Give me a thumbs up if you can hear me. Okay, for the record, she's giving me a thumbs up, indicates she can hear me. And then, Mr. Howard, are you ready to arraign her? Or are you ready for arraignment then?
Yes, Your Honor.
All right. I think I've already called the case. So yes, sir, go ahead. Well, let me ask you this. Has she received a copy of the indictment?
Ms. Riggins, have you received a copy of the indictment? Just yes or no? You have. Okay. Well, Your Honor, we'll be happy to waive arraignment.
Okay. Does she enter a plea of not guilty?
Yes, enter his plea not guilty.
Okay. And is there an enhancement paragraph on there?
It's a count two, Your Honor.
A count two. And so I'll note her pleas of not guilty to the indictment. Ms. Riggins, your next two court dates are July the 7th at 1:30 in the courtroom for discovery status. And then again on August the 4th at 1:30 for pretrial, and your attorney will have that down for you. However, I'm going to order her. What time are y'all? Or y'all aren't here tomorrow? It's Monday. You have some people tomorrow? I'm going to order Miss Riggins to show up to the Henderson County Probation Department no later than 11 a.m. tomorrow morning at 109 West Corsicana here in Athens to take a drug test. And so Miss Riggins, you'll take that drug test, and you're free to go after that, and then we'll go over the results in July.
Your Honor, what was that July date?
July the 7th,
7th, okay. And would that be at 9 a.m.?
1:30,
1:30? Thank you.
and then August the 4th at 1.
And the, let's see, and that one is for
The August 4th is pretrial. The July the 7th is
July 7th is what?
discovery status.
Okay, great. Okay.
And
And
I'll
she needs
recall
to-
I'm going to
she needs
recall the
to-
cases
She needs to appear in person for both of those, is correct?
unless she's running fever or has COVID.
Right. Okay. All right.
Just to clarify, Your Honor, did you say you're recalling the cases?
Yes, I'm recalling the capias.
Thank you.
Anything else?
That'll do it. Thank you, Your Honor.
Thank you, Mr. Howard. Appreciate you.
All right. Nice to meet you. Bye-bye.
Yes, sir. Likewise. Mr. Castleberry,
Yes, Your Honor, on page 1, I have Shane Clifton.
is this a plea?
And that's for a plea, Judge.
Did you hear back about anything about this glass? I'm gonna take it down myself. I'm gonna kick it out here in a minute because I can't hear anything. Mr. Clifton, before we get started, you can pull that mask down. A little break. I'm going to sign these and give the court reporter a little break here, so give me just a second. All right, this is cause number CR 21-0412-392, the state of Texas versus Shane Dooley Clifton. And this is set today for a plea on information. Is the state ready?
State's ready, Your Honor.
And on behalf of Mr. Clifton,
Defense is ready, Judge.
sir, is your name Shane Dooley Clifton?
Yes, sir.
And are you the same person that's been charged by information in this case with the state jail felony offense of unauthorized use of a vehicle?
Yes, sir.
I get you to raise your right hand the best you can, please. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir. So I'm done.
All right, you can lower your hand. Mr. Clifton, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Yes, sir.
I have to ask everybody that. And Mr. Clifton, have you ever been treated for any mental health or emotional issues?
Yes, sir.
And what have you been diagnosed with, if anything?
ADHD or bipolar.
Are you on medication for that?
No, sir.
Are you supposed to be on
No,
medication?
sir.
All right. Do you feel like you know what's going on in here today?
Most definitely.
And Mr. Castleberry, do you believe your client is competent?
I do, Your Honor.
The court's going to find he is competent. Mr. Clifton, you have not been indicted in this case. Do you understand that?
Yes, sir.
And In Texas, our Constitution guarantees that you cannot be held to answer for a felony in court. Mr. Riggins, either put a shirt on or stop your video. You cannot be held to answer in court for a felony unless or until ever an indictment is returned. Do you understand that?
Yes, sir.
And all you have against you right now is this piece of paper alleging that you committed this offense and signed by an assistant district attorney. Do you want to continue with this, or do you want to just stop and see if a grand jury will indict you?
No, sir.
All right, well, that information charges you with a state jail felony. A state jail felony carries a punishment range of not less than 180 days or more than 2 years in a state jail felony facility and a fine not to exceed $10,000. Do you understand the range of punishment?
Yes, sir.
In the plea bargain?
Your Honor, may I speak to Mr. Castleberry for a moment?
Sure. I do. Thank you.
All right, Judge, state's ready.
The plea bargain.
Thank you, Judge. The agreement is a 2-year deferred probation with a no fine, with attorney's fees, court costs. Conditioned on that probation is a $50 Crime Stopper fee, urinalysis testing, obtain GED within 24 months, 100 community service hours, complete substance abuse and evaluation and follow their treatment. And he is to have a home curfew by 10 p.m. each night, and that will be from 10 p.m. until 5 a.m. I don't think it says it on there.
And the victim on board? Plea bargain?
That I do not know. Let me-
They get the vehicle back?
Grandpa,
Grandpa?
grandpa.
How old is
By
he?
another prosecutor. so-
How old's the defendant?
He's okay with it, Judge. In fact, I think he instigated it.
How old is he?
That I'm not sure, Judge.
About like 70. I borrowed a vehicle for a little bit.
How old are you?
Oh, 19. My bad.
I'm gonna kick this glass out in a minute. Y'all watch out. All right, I was interested in knowing because of the curfew. I got it.
Yes, sir.
And I know how old your grandpa is now
Yeah.
too.
My bad.
All right, Mr. Clifton, is that your understanding of the plea bargain?
Yes, sir.
And Mr. Castleberry, is that your understanding?
It is, Judge.
Mr. Clifton, a few minutes ago, you told me you could read and write the English language. I'm going to go over 3 documents with you. The first is the agreed plea recommendation. Did you read and go over both front and back with Mr. Castleberry?
Yes, sir.
And did you sign it?
Yes, sir.
Do you have any questions about it?
No question.
The next document I'm going to show you is the defendant's waiver of rights to indictment by a grand jury. Did you read and go over that with Mr. Castleberry?
Yes, sir.
And did you sign it?
I did.
All right. And can you tell me what a grand jury is?
The-
Oh, don't look around for the answer.
Where they indict me.
Okay. The grand jury is a body of 12 citizens that meet in secret. And those citizens review evidence to determine whether or not there's probable cause to believe that you committed this felony. Do you understand that?
Yes, sir.
And you don't get to be there, and your attorney doesn't even get to be there. You don't even have a right to know when it's going to happen. You understand that?
Yes, sir.
And at that grand jury proceeding, if 9 or more of those 12 believe there's probable cause that you committed this felony, oh, no, look down, look at me, then they can return what's called an indictment. You understand that? But if less than 9 believe there's probable cause that you did this with your grandfather's car, well, then they can just no bill you. In other words, a letter would go to the jail saying he's been no billed, release him from the charge. You understand that?
Yes, sir.
All right. So right now, all there is a piece of paper saying that the prosecutor believed you committed this offense. And I didn't ask you earlier, did you go over that information, that piece of paper?
Yes, sir.
So you understand what you're charged with?
Yes, sir.
I think I went over the range of punishment. Well, if I didn't, the range of punishment for that is not less than 180 days, no more than 2 years in state jail, and a fine up to $10,000. Do you understand that?
Yes, sir.
All right. Now, do you want to just stop and see if a grand jury will indict you on this, or do you want to go forward?
No, sir. I'll go for it.
All right. Well, the last document I'm going to show you then is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that
Yes, sir.
with Mr. Castleberry? And did you sign it?
I did.
Well, if you read and went over these documents, I know that not only did he explain to you your right to a grand jury indictment, but also that you have many other constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, sir.
Do you want to do this plea bargain?
Yes, sir.
And I'll ask you, sir, how do you plead to that state jail felony offense of unauthorized use of a vehicle as alleged in the information? Guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
I'm guilty.
I hear the evidence.
Thank you, Judge. State offers in the evidence states 1 and states 2. States 1 is the offense report. States 2 is more in discovery compliance.
No objection, Your Honor.
As to your question on the victim, it appears that he filed an affidavit, not prosecution.
Gotcha.
Nothing
Admitted.
further. Rest in peace.
Nothing from defense, Judge.
All right, Mr. Clifton, then based upon your guilty plea and the evidence, the court has enough evidence to find you guilty. However, the court will follow the plea bargain, defers making any findings, places you on 2 years of community supervision. You do have 112 days credit as to any sentence you may eventually have to serve, and orders you to pay your attorney's fees, court costs, and then abide by all the regular and special terms and conditions of community supervision, including the 10 o'clock home curfew. Mr. Clifton, have you ever been on probation before?
No, sir.
Well, there's a whole lot of things you have to do and a few things you can't do on probation. You understand that?
Yes, sir.
Do you know what can happen to you if you violate any term or condition of this community supervision?
Yes, sir.
What can happen?
Go to state jail.
You know how state jail time is served?
Go to county and then I go to state jail.
Served day for day, generally speaking.
Yes,
You get 2 years, generally speaking, you do 2 years. You understand that? Here's what can happen. If you violate even one term or condition of this community supervision, a motion would be filed, a warrant would be issued for your arrest, you'd be brought back before the court, and at a hearing, if the court found that you violated even one term or condition, like maybe being out till 10:01 PM, the court could find you guilty, revoke your probation, and sentence you up to 2 years in state jail. Do you understand?
Yes, sir.
So would you agree with me? It's extremely important you abide by these terms.
Very, very important.
I hope you do, sir. Good luck to you.
Thank you, Judge. This is the paper on your misdemeanor that tells you what you owe.
Did you tell them I'm going to kick it out?
And thank you, Judge. Now be excused.
Yes, sir. Thank you. I can't continue. It's getting worse. I don't know why. I need to go to the VA and get my hearing checked. Like I was an infantryman. Older, oh, I'm 70. It's not there for single house. Mr. Scott.
Yes, sir. I've got Mr. Morrison for arraignment.
Let's see.
I just got appointed, so my name won't be on there.
Do I have a drug test back on?
Yes, you want my copy, Your Honor?
I got it right here. All right, this is cause number CR 21-0354-392, the state of Texas versus Gregory Morrison. And that is set for arraignment. Mr. Scott.
Yes, Your Honor. I got a copy of the indictment. His name is spelled correctly. We'll waive formal reading of the indictment and enter plea of not guilty to the indictment and not true to enhancements.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. You're going to receive 2 new court dates there in writing. That is July 7th at 1:30 for discovery status. And then again on August the 4th at 1:30 for pretrial. And also, I did order you to take a drug test this morning. And it appears as though you tested positive for methamphetamines, amphetamines, and THC, and admitted to smoking meth and marijuana yesterday, which means you're probably in court under the influence in a felony courtroom. However, I'm going to treat you like I do everybody else. I'm going to place conditions of bond on you. No alcohol, no drugs that are not prescribed, no illegal drugs, no marijuana, and that includes THC in whatever form it may come in. And if you need help, ask somebody. It's evident you got a problem if you're smoking the day you're supposed to be in, or the day before you're supposed to be in felony court for your arraignment. And so I've signed those bond conditions. Stay in touch with Mr. Scott and your bondsman, and we'll see you in July, where I will test you again. And if you test positive, I can't promise that you'll leave out that door. Do you understand? All right, sir.
Sign this. Thanks. I'll ask you real quick. Thank you, Your Honor. May I be excused?
Yes, sir, appreciate you. Mr. Mills.
Manuel Garcia.
All right, these are clause numbers CR 21-0088, 0089, and 0090-392, all styled the state of Texas versus Manuel Garcia, and all set for arraignment.
Judge, I've been over the indictments with Mr. Garcia. His name is spelled correctly. He understands the charges. We'll waive reading of all indictments and plead not guilty to all the indictments.
All right, sir, the court notes your pleas of not guilty for purposes of arraignment. You're going to receive 2 new court dates in writing. That's July the 7th at 1:30 for discovery status. And then again on August the 4th at 1:30 for pretrial. And as soon as you receive those reset notices, sir, well, I need to go over something else with you, sorry. You tested negative, but I'm still going to place you in conditions of bond because of these cases. No marijuana or THC in any form or format, no alcohol, no illegal drugs, and no drugs not prescribed. And you did test negative, but you're on conditions of bond now. I'm subject to test you, or you're subject to be tested anytime you come in court. You understand?
I understand, yes, sir.
Okay. As soon as you receive the reset notice and the written bond and the bond conditions in writing, you're free to go.
Thank you, Judge.
They told me you already have bond conditions.
You may.
I'm sorry.
Is he already on bond conditions?
Probably. I don't know.
No, since it's Judge Calhoun. Oh, I did order him. That's right. He came up with that in 30. So he don't, you remember that then.
Oh,
So
yeah.
those bond conditions are still in place. All right, you're free to go, Mr. Garcia. We'll see you in July.
Thank you, Judge. That's all I have. My excuse.
Yes, sir.
Thank you.
Yes, sir.
Judge, on page 9, I just wanted to carry the file through this morning. Follow up page 9.
Mr. McCluskey, did you take a drug test?
No, sir.
Oh, because he was late.
I live in Franklin. I dropped my little girl off at school at 7:30, so I couldn't close.
I got kids too, Mr. McCluskey, and I was here on time
Yeah, I understand.
because I have a responsibility to you to be on time for your arraignment. And I would just ask that you be on time for your attorney and me and the court staff and everybody else.
Yeah, I apologize.
I get it.
I had nobody else to do it.
Got to make arrangements. Life's hard sometimes, and I was a single father at one point in my life, so I understand. All right, I'm going to call your case. CR 21-0328-392, the state of Texas versus Terry McCluskey, set for arraignment. Mr. Harrington.
Your Honor, he has reviewed the indictment. His name is spelled correctly. He understands the charges, waive the formal reading, and plead not guilty.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. You're going to receive 2 new court dates in writing. That's July the 7th at 1:30 for discovery status, and then again on August the 4th at 1:30 for pretrial. However, since you were late, you weren't here to take your drug test early, so you're gonna have to take it now. So you're gonna go with probation, take the tests. When you get done, come back in the courtroom and we'll go over the results together.
Judge, I would like, one before, that apparently he takes ADD medication. What's the medication you take?
And Vyvanse and Respidol.
And that may be in case of some sort, I'm not sure.
Yep, we'll figure it out when he
We'll
comes
let you know
back in.
next week, so.
More.
I have a couple more that I don't believe are here. Stephen Henderson,
Let's go over the ones that have drug test results first.
Trey Walters.
And have I already arraigned him?
Yes,
He was late, right?
yes, he was, Your Honor. He was coming from out of town. He's on an ankle monitor with his parole, and he's not allowed to leave his residence till 8 a.m. That's
All right, Mr. Walters, your test is negative. You're free to go. Please don't be late again. All right.
Miss Cullifers.
Ms. Cullifer.
Yes, there with the green hair.
Ms. Cullifer, come on up.
She's our one from yesterday. She's the one who.
I remember. She appears to be under the influence to me, just for the record. Find her case. All right, this is cause number CR 21-0059-392, the state of Texas versus Danielle Cullifer. Ms. Cullifer was due in court yesterday. She did not show during court, but showed late. And she was reset to today. The court had already forfeited her bond. Today, Ms. Cullifer is present based upon her charge. The court ordered her to take a drug test, and I'll tell you her appearance and demeanor looks like she's under the influence right now. And she apparently has tested positive for methamphetamines, amphetamines, and THC, and admitted to smoking marijuana on 5/2 and took a capsule yesterday for sores, thinking it was antibiotic, and it must have been meth. You know what? It must have been, Ms. Cullifer. I don't know why you would take a capsule on the day you're supposed to be in court. And so what is her bond?
$10,000, Your Honor.
All right, I'm going to recall the capias. I'm going to set bond at $20,000 surety bond. I'm finding the previous bond insufficient. And so, ma'am, have a seat in the jury box. Ms. Cullifer, you need help. I'd rather you get help than go to jail. Promise. I promise you that.
I had two more, Your Honor. Stephen Henderson and Kevin Reed.
Stephen Henderson. Cause number CR 20-0514-392, state of Texas versus Stephen Henderson. And that is set for arraignment today. Is there Stephen Henderson in the courtroom? I see no one. I hear no answer. There's not a Stephen Henderson appearing via Zoom.
No answer.
No answer in the lobby. The time is now 10:20. The arraignment was set at 9 a.m. The court will entertain a motion.
Thank you, Judge. State or plus one.
And I'm not sure if they gave me a warrant. A
Right,
copy of the warrant.
Well, I'll take it under advisement. It looks like he's never even been arrested on this charge.
Well, he bonded out.
Or is that a bond? Oh, there was a bond was increased on indictment.
Yes. I
Where
think
was
there's-
notice sent to? Okay, it was an increase. I was fixing to say, I can't imagine a non-arrest PCS.
He was in jail when I was appointed. And, assuming he bonded out, I think maybe
AAA bail bonds.
his bond may have been increased. I believe the notice was sent to Oklahoma.
Ms. Forbes sent the notice to an address in Oklahoma. He was in jail in Oklahoma.
But what address? His address?
Yes.
All right, then,
The jail gave her, the jail in Oklahoma gave Ms. Forbes a new address and she sent notice. AAA is off the bond.
all right, granted, capious will issue, he'll be held with no bond.
Thank you.
And Kevin Reed?
And Kevin Reed is an old case. He was released from our jail due to some severe mental illness issues. Went to Terrell State Hospital and was released from Terrell State Hospital several years ago. I do not know his whereabouts any longer, but there's not, he never made bond and he never, the warrant was lifted on his case. I'd like to maybe talk to the state about whether or not they want to go forward on the case. I think it's maybe a 2018 case. Kevin Reed.
Let me do this. Was he in court or not? I'm trying to remember.
I don't-
He was sent to Terrell Creek.
And so, okay, so here's what I'm gonna do. I'm gonna reset his arraignment to June the 3rd. At what time is that one? At 9 a.m. and let y'all figure it out. Because it doesn't appear that he got notice.
Ms. Forbes sent a notice to Mr. Reed at his last known address.
Well, the one I got, I also sent a notice to last known address. It was returned to me. So I don't know if y'all have got a return, but
We'll just reset him and see what happens.
let me, okay.
Ms. Thompson,
Results are back. Y'all know Jonathan Arnold?
Mr. Arnold, come on up. He had that look about him this morning too. All right, this is cause number CR 21-0370-392, the state of Texas versus Jonathan Arnold. Mr. Arnold was arraigned this morning, not on a possession case, but based upon his appearance and demeanor. He appeared to be under the influence. He has tested positive for methamphetamines, amphetamines, and cocaine. And Mr. Arnold apparently admitted to snorting and smoking cocaine and meth on May the 1st, which was just about 5 days ago. And so, Mr. Arnold, you get your one free shot with me, just like everyone else. But it looks like you're under the influence now, and it's not a good idea to come to any court under the influence, especially felony court, when you're the defendant. And so I'm going to place conditions of bond on you. No marijuana or THC in any form, no illegal drugs, no drugs not prescribed, and no alcohol. You need help, Mr. Arnold. I'd rather you see you get help than see you in jail, I promise you. And so get help somewhere. You look like you're young too. And you're going down the wrong path with this. And so,
Can we have the defendant sign?
oh, I'm gonna see you in July
Thank you, Judge.
and I'm gonna drug test you again, more than likely. And I can't promise you you'll be able to leave out that door if you test positive, okay?
Yes, sir.
Sir.
Yes.
Anybody see Mr. Green? Cheryl Franco?
Here's the order on Miss Danielle. Thank you, Judge.
Ms. Franco was reset from last month. She was short of a summons.
Don't read
to be sent out. Clerk's office sent that.
Yes, we did that. Give it to him already. You're so
Why
ahead,
did we
baby.
do a summons? Yes, ma'am, thank you.
I think there was I don't think that
I'm just not realizing you set that for June 3rd. I had put a vacation letter in for the 3rd and the 4th. Is there any way we could do that on the 2nd for Mr. Reed?
She's got a vacation letter for June 3rd.
Right. Can we reset it for the second?
In here, it reverberates. Out there, you can't hear it.
The second at 9 o'clock would work well.
Thank you.
Second.
Also, Ms. Culliford would like to know if she promised to go to rehab, if the court would entertain reinstating her bond on the condition that she go to rehab.
It would depend. There, they got telephones in jail. If she can arrange to get in a rehab, I would certainly reconsider it.
So you wouldn't,
Not right now.
not today, but.
There's a there's a difference between a promise and proof.
Okay.
Ms. Culliford, there's promises and then there's proof. You give me proof, I'll let you out of jail to go to rehab. That's a promise. I don't have proof yet, though. I need proof. Like a letter that you've been accepted and that's where you're gonna go, and I'd probably have you transported straight from jail to there. So anyway, we're gonna have to do something with Miss Franco. Did you get her reset for that arraignment?
Yeah,
Okay.
second at 9 o'clock.
What are we gonna do about Franco?
There's not much else we can do.
All right, I'm gonna call it then. Yeah, we're gonna have to.
Reset them just to be able to get a warrant out.
Yep. I'm gonna call another case, CR 21-0213-392, the state of Texas versus Cheryl Franco. Is there a Cheryl Franco here? I see no one. I hear no answer. There's not a Cheryl Franco appearing via Zoom.
No answer, John.
Time is now 10:28. Ms. Franco was summoned to be here today. She was sent a summons to her last known address that she provided on her personal bond. And she is not present. The court will entertain a motion.
Thank you, Judge. State request bond forfeiture.
Granted, a capias will issue, she'll be held with no bond. Y'all gotta make sure you keep up with those capias because you'll never get these people in if those don't get issued on TCIC and NCIC. Who did we not get? Who is it? And I got a bunch. Yeah, go ahead and get Mr. Riskin in.
He heard Mr. Hood, Mr. Water is somewhere around here.
Did he take a drug test?
Yeah, I believe so.
I don't have it.
Right here, man.
Oh, he's taking it now? You get into criminal law, you lay down with dogs, you know, it's all saying. And I don't know which side's the dogs. Okay. Oh, yeah, hopefully he's better today.
Yeah,
All right, how about Penny Buckley?
she was the one that was arrested this morning by Henderson County. We'll reset her to June 3rd at 9 o'clock.
Y'all got that? Buckley, June 3rd, 9 a.m. Okay. How about Robert Chapman?
He was arrested on May 4th in County, so we need to reset him to June 3rd at 9 o'clock and issue a bench warrant. My understanding, he has $750,000 worth of bonds in Smith County.
I bet he ain't getting out anytime soon. Raymond Morgan,
Mr. Perkins is out trying to locate him right now.
cause number CR 21-0383-392, the state of Texas versus Raymond Morgan. Is there a Raymond Morgan in the courtroom? I see no one. I hear no answer. There's not a Raymond Morgan appearing via Zoom. All right, the court will entertain a motion.
State request bond forfeiture.
Granted, capias will issue. Mr. Morgan will be held with no bond. How about Casey Presswood?
He has a warrant. $15 million PR bond on an additional.
Okay, so we're gonna have to get these. I'm gonna just call the case that's not indicted. I mean, that was already. I guess call the case we already had a bond and a notice for. CR 21-0348-392. The state of Texas versus Casey Presswood. Is there a Casey Presswood in the courtroom? I see no one. I hear no answer. Is there a Casey Presswood on Zoom? I see no one. I hear no answer. No answer in the lobby. The time is now 10:32. Mr. Presswood or Ms. Presswood received notice. The court will entertain a motion. Granted, capias will issue. They'll be held with no bond. And then I'll note in 0349, there is already a capias out on that case.
Court sent notice to his address on the bond as well. As
I think that does it other than Mr. Weiner's client.
see. I don't think he's online yet, just other attorneys. Hit the goddamn door face a while ago with my forehead. That hurt like hell. And corners on that door facings are so damn sharp. Poe called here, which he was told to, but I couldn't call him back because his voicemail box is not set up. So I ain't gonna worry about the
Give me just a minute. I think we lost this feed for some reason. I don't know why that just came up with it. Oh, here we go. We're on here. All right, good afternoon, ladies and gentlemen. We're getting ready to take open announcements on the 1:30 docket. Just some quick administrative and housekeeping notes. If you are appearing via Zoom, please keep your microphone muted until it's your turn to testify or talk. Also, if you're appearing via Zoom, if you don't hit that little stop video button, we can see what you're doing. And although it might be entertaining, it can be distracting. I had a fellow on this morning that thought that he should appear with no shirt on. So if you wouldn't do it in court, please don't do it on Zoom. Have some respect. For the people here in the courtroom, if you want to wear a mask, wear a mask. If you don't want to wear a mask, don't wear a mask. It's not my decision. It's your personal decision. I'm not going to make a decision about your health. That's your decision and you're right. The inmates are required to wear a mask, but otherwise anybody else are not. So whatever makes you feel more comfortable and safe. So with that, we'll take open announcements on the 1:30 docket. Ms. Fallhaber. All right, this is cause number CR 20-0576-392 and CR 21-0324 and 0325-392. And all of these are styled the state of Texas versus DeMarcus Kaiser. And let's see, we've got an arraignment on the two new cases, 324 and 325. So Ms. Fallhaber.
Thank you, Your Honor. Mr. Kaiser waived formal reading of the indictment, represents that his name is spelled correctly, and enters his plea of not guilty for purposes of arraignment.
All right, and then on the status, do we have an offer to wrap all this up? Or?
Your Honor, there was a previous offer that's expired because of the new cases. There's currently no offer, so we need to put on that totality.
Okay. All right, then, Mr. Kaiser, then the court coach plea of not guilty for purposes of arraignment. You're going to receive two new court dates there in writing. That's July the 7th at 1:30. And when is the pretrial? You only gave me the. No, oh, I see it right there. And August 4th. So July 7th for discovery status and August the 4th for pretrial, both at 1:30. However, based upon your new cases, I'm going to order you to take a drug test today. You're going to go take the test. When you get done, come back in the courtroom. We'll go over the results together. Okay, sir? Thank you.
And Your Honor, I have another county hearing at 1:30 on Zoom. So is it okay if I run to my office and do that in the chat?
Yeah, sure.
Okay.
This one? Okay. That one always likes to go long. Yes, sir.
Tracy, who's your honor?
This is cause number CR 19-0860-392 and CR 19-0861-392, both styled the state of Texas versus Tracy Hoots, and both set for status. Where are we at? Okay. All right. Has there been an offer extended?
There has, Your Honor.
And it is for
I believe the most recent offer was 4 years.
4 years to do? All right. All right, Ms. Hoots, then the court notes that status has been held, that you've rejected the offer. We're going to place your case on a trial docket. Do we have a date now? or- Okay. However, I'm going to order you to take a drug test today. And so you're going to go take a test. When you get done, come back in the courtroom and we'll go over the results together. Yes, sir. Uh-huh.
Let's call Ray Morgan, so we can get started on this.
I thought this
I
was.
just signed it. but-
Oh, okay. Raymond Morgan. Where's he at?
He was on this morning's docket. Here's the cost. He didn't show up this morning.
All right, this is cause number CR 21-0383-392, the state of Texas versus Raymond Morgan. Mr. Morgan was supposed to be here this morning, but didn't show. Mr. Morgan, do you have an attorney?
I was gonna hire attorneys now that here, sir, because I don't know anybody out here.
What do you mean out here? Where are you from?
Yeah.
Smith County. Well, it ain't that far out here.
I know, I mean, really didn't have the money until now. I figured today would be a good day to come to court. I didn't make it this morning because I told him my car yesterday.
It is a good day to come to court. It's always a good day to come to court, especially when you've been told to come to court.
Is there, that's why I'm here.
I got you, but you're late. You're supposed to be here
Yes, I
this
am
morning.
late. Yes, I am.
Right. Okay. All right, I'm gonna find your bond insufficient. What's his bond? All right, I'm gonna set your new bond at $30,000 surety bond, sir. Have a seat in the jury box. You're supposed to be here this morning. No, he's gonna be positive. And I'm afraid if I do, he's not gonna come back. We'll be running after him. All right, let's see. Who else we have next? Mr. Stevens.
I got one that's ready, Your Honor. Brandon Zachary.
Sorry about it. It was a good day to come to court. Great day to be an American. So it's a great day to be an American. Let's sit at DA's office.
I apologize. Your
That's all right.
We're set on Brandon Zachary. I just received some printouts from his bondsman that he was admitted to UT Health Center at 11:40. I assume that's AM because the date is 5/6/2021. Did just receive a new offer today where they were going to make him a probation offer. I'm anticipating he's going to take that offer.
Can I see what you
Yes,
showed
sir.
me? Do you know why you admitted?
And I know he's had health issues in the past, but it doesn't really say what he's in there for.
Patient was seen. Doesn't say he was,
I apologize. I just received it literally a few minutes ago.
is he still there? He had heartburn?
I do not know, Judge. He's still there.
He went to the hospital for heartburn. And he took Rolaids. Can I see the doc sheet? It's just, it seems there's like the trend that people that are going to have their take a drug test always find their way into the hospital. Not always, but more than likely, or more than normal, not more than. Yeah. Had issues with him coming to court in the past.
I believe he failed a long time ago.
Back in June.
Yes, sir.
I'm sorry, back in February 2000, he made it do a UA. He was having chest pains and couldn't do it. State.
Well, we're gonna request a bond forfeiture if he's not here.
Yeah, I mean.
If he has a reasonable excuse,
Yeah.
if it ends up being something serious.
All right, this is cause number, or these are cause numbers CR 18-0729-392 and CR 20-0620-392, both styled the state of Texas versus Brandon Zachary. Is there a Mr. Zachary in the courtroom? See no one to hear no answer. There's not a Mr. Zachary via Zoom. All right, court will entertain a motion.
Thank you, Judge. State request bond forfeiture.
And Mr. Stevens, I appreciate it, but that was 8 a.m. for heartburn. And so the motion is granted a KP issue. He'll be held with no bond. And if you got more, just let me know. And I'll reconsider.
And I'll track them down and they can hold their offer open, and I may see about setting up quickly if we can.
And if he doesn't find his way into court, I don't know whether the court would accept the offer for probation if he can't show up for court. So it'd be in his best interest to get here. Uh-huh. All right, anything else? All right, here's what I'm going to do, ladies and gentlemen, because I know that y'all are still working some stuff out. I'm going to call through the docket. If you hear your name, just let me know that you're here. You don't have to come up. Christy Farrell, got you. Rashawn Miller,
He's present in the hallway.
got you. James Williamson.
Judge, he contacted the office that he was going to be running a little late this morning. I'm sorry, this afternoon, called this morning, so he was a little late this afternoon. I understand what in this court, but just let you know that.
All right, it's cause number CR 19-0846-392, the state of Texas versus James Williamson. Is there a James Williamson in the courtroom? See no one, I hear no answer. Is there a James Williamson appearing via Zoom? The only James I see is Mr. Mills. His name was called in the lobby. There's no answer. The time is now 1:41. Docket was for 1:30. Court will entertain a motion.
State request bond forfeiture this time.
Granted, KP will issue. He'll be held with no bond, and we'll see when he gets here. Kyle Wing.
Present in the hallway.
Okay. Justin Combs. Gotcha. Charlie Simpson. Got you. Demetrius Moore. He's back there in the corner. Ricardo Abundez. Got you. Walter Bryson. Walter Bryson.
Judge, I was hoping he was on Zoom.
Did he get prior approval for Zoom?
I got some information from former bail bonds this morning that I gave Mr. Mills, but I I haven't sent a link to him.
Why would he
Judge,
appear
all-
via Zoom?
Well, Judge, all I know, I got a text, Mr. Inslee gave me some information this morning about his health condition that outlined what all he was having health problems with. And basically that text said that he could not get here. And then I gave the Zoom link to his bondsman who was supposed to give that to them. And so I'm was hoping he was going to be on Zoom, but I don't know.
All right, well, again, it's a drug case. May I see the docket sheet? And he's refused to give a sample back in 2020 and admitted he'd be positive. So he's on conditions of bond. So, all right, well then, I'm going to call it cause number CR 20-0506-392, the state of Texas versus Walter Bryson. Is there a Walter Bryson in the courtroom? I hear no answer. I see no one. Is there a Walter Bryson appearing via Zoom? I don't see anyone. Is he in the lobby? All right, time is now 1:43. The docket was for 1:30. Mr. Bryson has failed to appear. The court will entertain a motion.
Thank you, Judge.
Granted, case issue, he'll be held with no bond, and I'll be here till early this afternoon. Mr. Mills, you got some other stuff ready?
Judge, we can make announcements on my cases. Yes, sir.
Okay, I figured while you're there, I'll call through the rest of the docket when I'm done with you. right.
Mr. Abund is on page 4, should
Yes,
be in
sir.
custody, and there's Miss Meeks there, Norma.
I do not see her.
Judge, and I can tell the court, I've been speaking with prosecutor, Ms. Pace, about this case, and we've gotten an offer of 35 years. I've been over to see Mr. Abundis with Ms. Meeks prior to getting that offer. And after talking with him, is the reason that Ms. Pace and I are talking. And so we do have an offer, but I have not, and Ms. Meeks have not relayed that offer to Mr. Abundis yet. So I was going to ask I feel like there's a pretty good chance we may have it worked out. If the court could maybe give us a couple of weeks or so for another announcement. Or
How about if y'all want to reset it by agreement?
That's fine, Your Honor. I did want to let the court know, and Mr. Mills, I haven't had a chance to talk to you today. We represented this case to grand jury, so it's going to be a re-indictment, but we're still open to the resolution we discussed of 35 years.
Is Ms. Meeks going to be here today?
I think I haven't seen her today. Normally I'll double notify her. She's notified the court, but I'll send another email just to remind her. And I don't think I sent her a little email, so.
All right, well, then let's just do that. I'm going to reset his case for June the 3rd for status by agreement.
And I think we'll either have a resolution or know that we don't have a resolution by then.
1:30, Your Honor.
Mr. Abundez, I'm resetting your case to June 3rd at 1:30. June 3rd, 1:30. I think you understand something. What else you got, Judge?
Judge, I have Amanda Smith who should be there.
Amanda Smith. Come on up, Ms. Smith. All right, this is cause number. It's your attorney's right there. He can see and hear you. Cause number CR 20-0496-392, the state of Texas versus Amanda Smith, set for status.
Says the last offer I've received from the state, I believe, was 15 years, and Ms. Smith does not want to take that offer.
Did you receive the medicals and the 911 audio in this case? Mr. Mills?
You know why he can't? Because I took this microphone off and I was trying to pull this glass out.
James?
Can you hear him? Okay.
Mr. Mills, did you receive the medical paperwork in this case and the 911 audio recording?
I think I did.
So we trust probably need to set it for trial.
Does she have any alleged prior felonies?
She does not.
Okay. All right, well then, Ms. Smith, then the court's going to deem status is held. Your case will be placed on a trial docket. And are we given notice now? And so stay in touch with your bondsman and Mr. Mills, and you'll receive notice when your case gets close to the top.
Okay.
All right, you're free to go, ma'am. Thank you.
Judge, and then I have a Taylor Walker.
Taylor Walker. All right, this is cause number CR 20-0543-392, the state of Texas versus Taylor Walker. Set for status today, the time, let's see, is there a Taylor Walker in the courtroom? I see no one, I hear no answer. There is not a Taylor Walker appearing via Zoom. There's not a Taylor Walker in the lobby. Time is now 1:48. Status was for 1:30. The court will entertain a motion.
Thank you, Judge. State request bond forfeiture in this case.
Granted, capious will issue, and I don't know whether it's a he or she, but they will be held with no bond. I think that's the politically correct way I'm supposed to do it now. Is it she? I think it's supposed to say they.
They.
Be
That's right.
woke. They. Okay.
And Judge, that's all I have, I believe.
Is that everything? Yep,
think
that's
so.
it. All right, thank you, sir.
Thank you, Judge.
Yeah, I don't know. Yes. Is he still sick? You got a deleted sample? Yeah, I'll deal with him in a minute. Can I get that cause number? Oh, I got the cause number right here. All right, yes, Mr. Stevens.
Judge, I have George Smith, he was ordered back from yesterday.
Yes, we were just talking about him. We can get Mr. Smith in here. May I see the docket sheet? He was from yesterday. It was the guy that was thrown up in the bucket.
Yes, sir. That's him.
Yes.
I'll answer, Your Honor.
No, it was yesterday. He was sick yesterday. And the jail
He showed up today. At what time?
1:15, I told him to come back in the courtroom.
Well, he didn't listen to you evidently.
No, when I came over here earlier, I saw.
Oh, there he is.
Oh, here he is, Judge.
Oh, okay.
I was in the restroom, sorry.
That's all right. All right, this is cause number CR 19-0767-392. I need to see the doc sheet again. I'm sorry. And did I give you the drug test results back? I didn't think he was here, so I thought I handed it. Oh, right here in front of him. CR 19-0767-392, the state of Texas versus George Smith. Mr. Smith appeared yesterday, but was having some issues, so he couldn't produce a sample. I ordered Mr. Smith to appear today for a drug test. He did. And it appears as though there was a diluted sample provided and it was positive for methamphetamine. And Mr. Smith allegedly admitted to probation that he had tasted some meth on April the 30th. And Mr. Smith, you had previously failed a drug test in February of 2020, and I placed bond conditions on you. And so what is his bond?
8,500.
I'm sorry?
8,500.
Yeah, let's double check. Should be on top right-hand corner of the indictment. 8,500. All right, then, Mr. Smith, the court finds your bond insufficient. Your bond is now $17,000 surety bond, and remanding you into custody.
I'll come talk to you in just a few minutes.
We have an offer on him?
I do, Judge.
And what is it?
I don't know offhand. It's in my.
Did you have a probation and a jail offer?
No, sir, just jail.
Okay.
Yeah, that's. Judge, I've got some other cases, but I have a 2 o'clock Zoom thing, so I'm gonna go do that. if
I'm
may
not gonna
come back.
be, I mean, we gotta rush. Who else is it? It's just.
I've got Mr. Henderson motion to withdraw, and I've got Mr. Pearson. We're working on plea papers.
Okay, so you'll be back to do the plea then?
Yes, sir.
All righty.
Thank you.
Mr. Weiner.
Yes, page 2, Christie Carroll.
It's a plea.
Almost. Real
Right.
close, yes.
These are cause numbers CR 19-0439 and CR 20-0577-392, both styled the state of Texas versus Christie Farrell, and both set for a plea today.
They are, Judge. My understanding is Mr. Head was speaking with the state and asked for an alternative offer because one of the cases is state jail, one of them is TDC. And so we got that offer. I just need a little time so that Mike can go over the two options with her, but we will resolve it via plea.
When do y'all want to come back?
And anywhere 2 weeks, 30 days.
June 3rd?
June 3rd at 1:30.
June 3rd at 1:30. Miss Farrell, you're the one in jail. You all right with that?
Yes, sir.
All right, June 3rd, 1:30.
Thank you, Judge.
We'll get you a reset slip.
Okay.
Are you handling Mr. Miller?
I'm sorry?
Are you handling Mr. Miller?
I am.
Okay.
He's gonna.
You ready?
No, I'm not. I've
Okay.
got plea paperwork for him, Judge.
I'm just seeing, how about Kyle Wing?
Yes, I'm ready on
You
that
ready
one.
on that one?
Yes.
Kyle Wing. And I'll need to see the docket sheet on that one. All right, this is cause number CR 20-0177-392, the state of Texas versus Kyle Wing, and set for trial docket status.
Judge, again, this is Mr. Head's case. They're still working towards a resolution on this. I don't know that they will reach an agreement, but still talking with the state.
Okay, well then, Mr. Wing, court is going to place your case on a trial docket. What number is he, by the way?
He's been on trial docket for a while, but he's 42.
Close.
What number? I'm sorry?
42, and
Oh.
so that could go like that.
Sure.
All right, Mr. Wing, then you're not going to receive a reset from me. I'm not going to drug test you. You've tested negative the past 2 times. And so you will receive notice when your case is close to the top, but stay in touch with Mr. Head or Mr. Weiner and your bondsman, okay?
Yes, sir.
All right,
May
you're
he
free
be
to go.
excused? I'll circle back around with paperwork.
All right, I'm going to continue on where I left off, calling cases that have not been resolved yet are called Gerald Henderson. Gotcha. And then Christopher Pearson. Got you. Derek Kiefer. UA. And then Brandon Zachary, I've already dealt with that. And then Martha Beat. Okay, are you ready, Ms. Thompson?
Yes, Your Honor.
Okay, Ms. Beat, come on up. Yeah. Oh, that's right. All right, this is cause number CR 20-0666-392. The state of Texas versus Martha Beat, and this was set for pretrial yesterday. Let's see. Did we hold pretrial or not? I don't believe.
No, she was on Zoom.
She appeared on Zoom, said she'd been exposed to COVID. And I ordered her to appear today. So, ma'am, I'm going to order you to take a drug test. You're going to go take a drug test today. When you get done, don't go anywhere until we talk. Come back in the courtroom. We'll go over the results together. Okay. All right, Ms. Thompson, we'll let you know. But we already did hold pretrial yesterday, didn't we? That's okay. We'll go ahead and get her drug test and we'll hold it when she gets back.
Your Honor, I'm just gonna hang on till she gets the results back.
Thank you, ma'am. Yeah, thank you. All right, anything else ready? Going once, going twice. I'll take a recess. Y'all let me know when we have something. Oh, I never signed that. We've got order for who's I never signed. Oh. I got you. Okay. Do we have results back?
No.
Okay.
Somebody about to take care of this. This morning, was it Martha? Yeah, she ain't showed up. Oh, that's who they are. I'm gonna say whatever she gonna say. She gonna feel it, she never feel it, they gonna feel it. I'm drinking the same thing. Yeah,
Gentlemen with the mask on.
Is a life crew. Okay, oh, okay. No, I didn't know how it's gonna be over here. You know, Dave, you very cute. I like calling me that, but two friends. Thank you. So what we're gonna do now. So we should do that. And I'll give you those pairs. So we should do. Check and do it, okay? That's what, yeah, he knows the big one. So why you saying the case for now? And why people think it should be on the court? You still at wrong. Yeah. Clearing that place out. When they got that stimulus check, they just, like, are y'all open? Well, hold. They cleared out that store. Yeah, it's back. But we have to talk to the judge. I need to look at that. Judge now, but we have to. I've been doing this for 7 years.
I was scared.
County Attorney's Office.
Thank you.
Okay, I start working on this.
We do it. Oh, it's still.
No, that's my mom's thing.
Yeah.
All right. Don't be seated. Thank you. All right, continuing on with open announcements on the 1:30 docket. Mr. Stevens.
Sure, on this one. I have Eric Piper for Cleveland.
All right. And Ms. Hoots, you're free to go. We'll see you in your next setting. Kiefer?
Yes. Maybe page 5, I think that ended at page 4.
I got it.
Okay.
All right, this is cause number CR 20-0446-392, the state of Texas versus Derek Kiefer. Set for status today, however, a plea has been presented to the court. Is state ready?
Yes, Your Honor, state's ready.
And on behalf of Mr. Kiefer,
We're ready.
right, sir, is your name Derek Scott Kiefer?
It is.
And are you the same person that was originally indicted by Henderson County Grand Jury in count 2? I'm sorry, is it count 1? Count 1 of this indictment for the state jail felony offense of abandoning or endangering a child.
Yes, sir.
I can get you to raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God? I do. You can lower your hand. Mr. Kiefer, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
I am.
if it turns out you're not a US citizen and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Kiefer, have you ever been treated for any mental health or emotional issues?
No, sir.
Do you understand what's going on in here?
Yes, sir.
And Mr. Stevens, do you believe your client is competent?
I do, Your Honor.
Then the court's going to find he is competent. Mr. Kiefer, I know that you've been arraigned on this case. However, would you like the prosecutor to read the indictment out loud here in the court?
sir.
Do you understand the charge?
I do.
Y'all have paragraph B, that's supposed to be, is that the alternate way or is that another count? Because you've got them paragraphs, not
I think there's
counts.
paragraphs and counts.
Is there? I see it. I didn't flip it up for me.
Go paragraph A.
I got you. All right, well, Mr. Kiefer, that count one of that indictment, that charges you with a state jail felony. A state jail felony carries a punishment range of not less than 180 days or more than 2 years in a state jail felony facility and a fine not to exceed $10,000. Do you understand that range of punishment? Do you understand the range? of punishment? You have to answer it loud. Just take it down. We're planning to do that. All right, and the plea bargain?
Thank you, Judge. On count one, the agreement is for 2 years state jail time to be probated for 3 years, plus attorney's fees and court costs as part of the conditions of probation. Mr. Kiefer is to take AA and or NA meetings, pay $50 to the Child Advocacy Center, $50 to Crime Stoppers, urinalysis testing, obtain GED within 24 months, 200 community service hours, take the drug offenders program, complete substance abuse evaluation and follow their treatment. And if a CPS case ends up getting filed, he's to cooperate and follow any kind of child safety plan with CPS. And the state will ask this court to take into consideration count 2 of the indictment.
All right, is that your understanding of the plea bargain, Mr. Kiefer?
It is.
Is that your understanding, Mr. Stevens?
Yes, sir.
Well, Mr. Kiefer, a few minutes ago, you told me you could read and write the English language. I'm showing you 2 documents here. The first is the agreed plea recommendation. Did you read and go over both the front and the back and sign them with Mr. Stevens?
I did.
Do you have any questions about it?
No, sir.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages and sign that second page?
I did.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you went over with your attorney?
No, sir.
Well, if you read and went over these with Mr. Stevens, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, sir.
Do you want to do this plea bargain?
I do.
And I'll ask you, sir, how do you plead to count 1 of that indictment, that state jail felony offense of abandoning or endangering a child?
Plead
Guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
I hear the evidence.
Thank you, Judge. State offers in the evidence, states exhibit number 1 and 2. States 1 is the offense report, states 2 is Morton discovery compliance.
No objection.
Nothing further, rest and closed by the state.
Admitted.
Rest and close as well.
All right, Mr. Kiefer, then based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that state jail felony offense in count 1 of the indictment. In punishing you, the court will consider the count 2 charge of that indictment and follows the plea bargain, sentences you to 2 years in the Texas Department of Criminal Justice. However, the court will probate that, places you on community supervision for 3 years. You do have 3 days credit as to any sentence you may eventually have to serve, and orders you to pay your attorney's fees, court costs, and abide by all the regular and special terms and conditions of community supervision, including successfully cooperating and following your CPS family plan of service. And Mr. Kiefer, have you ever been on probation?
Yes, sir.
And did you successfully complete it?
I did.
So you know what it takes.
Exactly.
You know what can happen if you violate this probation.
Oh, sir.
What can happen?
Go to jail.
State jail, is that correct? You know how
Yes,
state
sir.
jail time is served?
Basically like any.
Generally day for day.
Right.
All right, here's what can happen. If you violate even 1 term or condition of this community supervision, a motion can be filed, a warrant would be issued for your arrest, you'd be brought back before the court, and if the court found it true that you violated even 1 term or condition at a hearing, the court could revoke your probation and sentence you up to 2 years in state jail. You understand?
Yes, sir.
All right, good luck to you, sir.
Thank you.
You see probation and Mr. Halbert.
Your Honor, may I be excused?
Oh, and I forgot to tell you, Mr. Kiefer, now that you've been convicted of that felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. If you have any questions, consult an attorney.
May I be excused, Judge?
Yes, sir. Thank you. Ms. Beat, I'm going to handle her real quick since she just has a drug test. Ms. Thompson?
Yes, sir.
I forgot, we didn't hold pretrial before I ordered her. This is cause number CR 20-0666-392, the state of Texas versus Martha Beat. Ms. Beat took her drug test, she passed it, and let's hold pretrial.
Standard motion for discovery.
Any objection?
No objection to that, Your Honor, and the defense does not have any pretrial concerns at this time.
All right, well then, the motion is granted. The court deems pretrial is held. Ms. Beat, your next court date is June 3rd at 1:30. And so as soon as you receive that in writing, that reset notice, you're free to go to stay in touch with your bondsman and Ms. Thompson. Thank you. All right, thanks for hanging around, Ms. Thompson.
You're welcome, sir. Bye.
Bye-bye. All these I'm done with. Yes, ma'am.
Good afternoon, Robert.
Good afternoon.
I'm Beverly Melventry. I'm here for Mr. Demetrius.
We've met before, haven't we?
I didn't know Ashley was your wife.
Yeah, well,
We're Facebook friends.
you know, they call us Beauty and the Beast. I don't let anybody else call her Beast.
Oh, no. She was showing the boys.
What's that?
I saw y'all on Facebook.
Oh, yeah.
with the boys.
And who do you have?
Demetrius Moore, Your Honor.
Mr. Moore, come on up. So you are recently retained then?
Yes, Your Honor. He has 2 cases, but the attorney said she can handle both, so I'm stepping in to take the sexual assault of a child. She's going to continue with the other 2 cases. Mr. Moore made that decision. I haven't had an opportunity to speak with the other counsel, but what I did do, I sent a motion to substitute. Last week, she was out of town to get her signature. I also sent a letter of representation to the court here. Hopefully, when I get back, she will have signed that for me to sub in on this case. Then I have opportunity to review the discovery.
Well, he's set, my issue with him is he's set, so you're going to take over all the cases?
No, just one.
Okay,
This
just one. So, but he's set for trial on the other ones, correct? Okay. All right, well, then I'll call it CR 20-0395-173, the state of Texas versus Demetrius Moore. And court notes that Ms. Mellentree is now his attorney on this case. And I'm just going to reset it to give her time. How much time you need?
Yes, I think they told me June 3rd.
Okay,
That's ample time for me.
June 3rd at 1:30.
Thank you, Your Honor.
Yes, ma'am.
Good seeing you again.
Yeah, good to see you. I know it's been a few
Tell
years.
your wife I said hi.
I will. Thank you.
Mhm.
And as soon as you receive that reset notice, Mr. Moore, you're free to go.
Thank you. My big excuse.
Yes, ma'am. I didn't mean to sign that because we didn't. You think? Mr. Weiner?
Yes, it's pages 2 and 3 with Sean Miller.
Is this a plea?
It is. It's a first part of a plea. It's an open plea, Judge.
Gotcha. All right, this is cause number CR 20-0252-392, the state of Texas versus Rashawn Miller. And this is set today for a plea. Is the state ready?
We're ready, Your Honor.
And on behalf of Mr. Miller,
We are ready, Judge.
all right. Sir, is your name Rashawn Miller?
Yes, sir.
And are you the same person that was originally indicted by Henderson County Grand Jury for the state jail felony offense of violation of civil rights of a person in custody?
Yes, sir.
If I can get you to raise your right hand, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Mr. Miller, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not a U.S. citizen and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Miller, have you ever been treated for any mental health or emotional issues?
No, sir.
You understand what's going on in here today?
Yes, sir. Yes, sir.
And Mr. Weiner, do you believe your client is competent?
I do, Judge.
Court finds he is competent. Mr. Miller, I know that you've already been arraigned on this case. However, would you like the prosecutor to read the indictment against you out loud here in the courtroom?
No, sir.
But do you understand the charge?
Yes, sir.
Well, as indicted, that charge is a state jail felony. A state jail felony carries a punishment range not less than 180 days, nor more than 2 years in a state jail felony facility, and a fine up to $10,000. Do you understand the range of punishment?
Yes, sir.
And what is the plea bargain, if any?
Just an open plea, Your Honor, on the state jail felony.
With the straight up dismissal of the sexual assault.
I'm sorry?
With the straight up dismissal of the sexual assault, the other case.
No, when you say straight up, that is not contingent on him pleading guilty, or is it?
It's contingent on a guilty plea, is my understanding.
Okay, so then we got to be clear on the record. So the only bargain he's getting is not a recommendation on punishment, but the dismissal of a sexual assault charge.
That's correct,
Yes,
Judge.
sir.
And so, Mr. Miller, do you understand? Is that what your deal was, that you would plead open to this charge
Yes, sir.
in exchange for them dismissing that other charge?
Yes, sir.
All right. And is that your understanding, Mr. Weiner?
It is, Judge.
And Mr. Miller, a few minutes ago, I asked if you could read and write the English language, and you told me you could. I'm going to go over 2 documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back with Mr. Weiner and sign it?
Yes, sir.
You have any questions about it?
No, sir.
Second document I want to refer you to, I'm going to go back to this one, is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document?
Yes, sir.
And did you sign that second page?
Yes, sir.
Do you have any questions about it? And let me go back to this agreed plea recommendation. I'm going to write on here, open plea and dismissal of the cause number. That way it's clear that there was a bargain.
That's fine with the state.
Okay, I just want to make sure it's on the record, and so,
I'm actually not sure if it was indicted or not. I'm sorry. It's actually Mike's case.
here, I'm going to hand it back to y'all and let
Sure,
y'all put the language you
absolutely.
want. I just want to make it clear for his purposes that,
Sure. No, that makes sense.
and protecting you, Mr. Miller, they can't come back and re-indict you for that, if you bargained. If they received the benefit of you pleading guilty, you understand what I'm saying?
Yes, sir.
You'll want that.
Yes, it's good to be clear on that. Thank you, Judge.
CR 19 or 18. Oh, is it on here?
It does have a cause number.
Okay.
CR 2251.
Okay, I gave him the sheet to write it on there.
Okay. You gonna do this?
No, I know how to do it. I just wasn't sure if you want to word it a certain way, and I'll just initial it.
And don't get me wrong, I don't think the state would, but a grand jury could.
Sure.
All right, and so then if you read and went over these documents, Mr. Miller, I know that Mr. Weiner explained to you that you have many constitutional rights, including the right to trial by jury. Now, I'm going to kind of go off what I normally go here is, in this case, the only bargain you got for this was that dismissal of that 0251 case. You understand that? And so do you understand that if you plead guilty, when you come back for a hearing, you will have waived your right to have a jury determine any punishment in your case? Do you understand that?
Yes, sir.
And in Texas, you have a right in punishment to either have a jury assess punishment if you're found guilty or plead guilty, or the court. By doing this today, you would be waiving your right to have a jury, and the punishment would be in front of the court. Do you understand that?
Yes, sir.
All right, and is that what you want to do?
Yes, sir.
You want to waive that constitutional right under Texas to have a jury assess your punishment and enter into this plea bargain?
Yes, sir.
Then I'll ask you, sir, how do you plead to that state jail felony offense, a violation of civil rights of a person in custody? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
Right, or am I gonna hear evidence now, or well, I gotta have it now to find him guilty.
Yes, sir.
We're
Oh,
asking
you're
the
gonna
court
ask
to
to
defer.
Understood.
Yes, and order of PSI as well, Judge.
For the guilt innocence phase, Your Honor, I'd offer states 1 an offense report and states 2 is Michael Morton compliance.
We have no objection.
Admitted.
State rests in the guilt innocence phase.
We'd rest, just ask the court to defer finding a guilt or PSI.
Okay, at this time, then the court, based upon your guilty plea, Mr. Miller, the court has enough evidence to find you guilty. However, the court's going to defer making any finding. And we will set this for punishment and the punishment phase of the trial and order a PSI. When do we want to set it for punishment?
Can we have a little longer, just so we can get witnesses and everything lined up?
Yeah, that's just a little over a month. Get something in July.
That'd be great. Something like 6 weeks out.
July 9th, 10 a.m. for punishment. And then let's see, PSI.
Yes, I was making sure Mike wasn't out of town.
Let's make that, that's a Monday? This is Monday before that. And let's do the 21st. And so the PSI will be due June 21st. All right, so we will recess this trial and proceed with punishment on July 9th at 10 a.m. And Mr. Miller, just remember any conditions of bond you may have. Stay in touch with your attorney. See you on July 9th.
Just give
Thank you,
Mike
sir.
a call next week, okay? Hey, Tolan, do you need to see him now, or we all call him? Okay.
You didn't schedule anything June 4th to the 6th. I told you not to do that, right? Don't do that. June 4th to the 6th. But don't do anything for the 6th. I'll be at the Ron Wolf's. Okay.
Don't have any excuse. Thank you.
I didn't think about that. I was thinking Friday through Monday. Be at Ron Wolf's pitching range. All right, anything else ready? Mr. Harrington, you got anything?
Yeah, I think we have a plea on Mr. Simpson ready to go.
Okay.
Almost ready to go. I think he needs to be sworn to.
Sure.
You want to announce on terms or wait for that plea?
We doing Mr. Combs?
I'm sorry?
What are we doing, Mr. Combs?
Oh, we're gonna ask for a reset, Judge. We do have an announcement to make.
Okay, all right, Mr. Combs, come on up, sir. All right, this is cause number CR 20-0327-392, the state of Texas versus Justin Combs, and set for status.
Your Honor, if the court recalls, the last time Mr. Combs was set, the state relayed to the court that we had made an offer to Mr. Harrington of 20 years TDC on a manslaughter with the plea of true to the deadly weapon allegation. I spoke with Mr. Harrington this morning. He made a counter offer to me. The victim's family, they're present here in the courtroom today, and Ms. Palmer and I spoke with them this afternoon before court. We made them aware of Mr. Harrington's counter offer. They're mulling it over. We're mulling it over. We're going to ask the court to set it out for about another month or so and see where we're at then.
All right, then I'm going to reset this. Mr. Combs, you're the one in jail. You all right with that? All right, then I'm resetting this to June the 3rd at 1:30. And y'all are going to have a resolution or something worked out by then, or I'm going to put it on the trial docket.
Yes, sir.
because this is a case needs to be tried if we can't work it out. All right, so Mr. Collins, as soon as you receive that reset notice, you're free to have a seat. Let's see. Mr. Harrington, yes, sir.
Since nothing, we just need the blue paper sworn to, we'll be ready to go.
You got the papers?
Yeah, thank you, just.
We'll just sit right there. It's easier for her to do it right there at the table. Is it easier for you to do it over there? Okay. Yeah, she's going to swear you and then I'll call you up. Get out of the way. Hold that progress. Josh at lunch, I saw him when I was coming out of McAllister's. He said he's been working on the 173rd because they're having the opposite issue where they have sound but no video. And he said, so he thinks he just needs to reset everything. Maybe the storms knocked it out this weekend. You can wear those to a wedding.
Yeah, that was originally the plan to wear to a wedding. Yeah.
Where'd you get those at? Hey, you can walk in the lake and come out and it just drain on you.
Yeah.
Come on up now, Mr. Simpson. All right, this is, can you pull your mask down a little bit? There you go. That way you can talk. All right, this is cause number CR 21-0414-392, the state of Texas versus Charlie Ray Simpson. And this is set for a plea on information today. Is the state ready?
Yes, Your Honor, state's ready.
And on behalf of Mr. Simpson?
We're ready, Your Honor.
All righty, sir, is your name Charlie Ray Simpson?
Yes, sir.
And are you the same person that was charged by information in this case with the state jail felony offense? I'm sorry, with the third-degree felony offense of tampering or fabricating physical evidence?
Yes, sir.
If I can get you to raise your right hand the best you can, please. Do you solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
All right, sir, you can lower your hand. So hold on, we're going to do,
We're doing lesser of an information. It's a little different.
why don't you just file the information on the
That
lesser?
should have been done, but the original lesser wasn't a true lesser. So we just changed.
Gotcha. All right. All right. Here we go. Mr. Simpson, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, you can have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Simpson, have you ever been treated for any mental health or emotional issues?
No, sir.
Do you understand what's going on in here today?
Yes, sir.
Mr. Harrington, do you believe your client is competent?
Yes, sir, I do.
And the court finds he is competent. Mr. Simpson, first of all, you've not been indicted by a grand jury on this case. You understand that?
Yes, sir.
And in Texas, you can't be held to answer to a felony in court until or unless a grand jury indicts you. Do you understand that?
Yes, sir.
All right. Do you want to continue on with this plea bargain? And I'm going to go into detail with that a little bit later. You just want to stop right now.
Go on.
Okay. Well, Mr. Simpson, then you have only been charged by information, which is just a sheet of paper, looks similar to an indictment, but it's just an allegation from the assistant district attorney alleging you committed this felony and signed by them. The one that's been filed on you is a third-degree felony. A third-degree felony carries a punishment range of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, sir.
However, it's my understanding that you have this deal worked out with the state where you'd plead guilty in exchange for them recommending a state jail felony sentence. A state jail felony carries a punishment range of not less than 180 days or more than 2 years in a state jail felony facility and a fine not to exceed $10,000. Do you understand both those ranges of punishment in the plea bargain?
Your Honor, and we're going to go forward on the 1244B section of that state jail.
Okay, hold on. Yeah, there it is. And further, they're also recommending that this state jail felony be punished and convicted under 1244 of our penal code. So the conviction would be that of a Class A misdemeanor. The Class A misdemeanor carries a punishment range of up to 1 year in the county jail and a fine of up to $4,000. You understand all three of those ranges of punishment? And the plea bargain?
Thank you, Judge. We sign off. Judge, the agreement is for 76 days in the county jail under the attempted tampering the state jail pursued under 1244B, punishment and conviction, plus attorney's fees, court costs, credit for 76 days in the county jail. And there's also an agreement to forfeit a machete in this case.
Is that your understanding of the plea bargain, Mr. Simpson?
Yes, sir.
Is that your understanding, Mr. Harrington?
It is, Your Honor.
Mr. Simpson, a few minutes ago, you told me you could read and write the English language. I'm going to go over 3 documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back of that and sign it with Mr. Harrington?
Yes, sir.
Do you have any questions about it?
No, sir.
The next document I want to refer you to is, and I went into this a little bit earlier, but this is the defendant's waiver of rights to indictment by a grand jury. Did you read and go over that with Mr. Harrington? Right, and do you know what a grand jury is?
Yes, sir.
Can you explain it to me?
A grand jury is a jury of 12, the grand jury is what indict you when they send your case into the grand jury. They have enough evidence that's into the grand jury and the grand jury indict you. Sometimes they pick you up and you have another bond to make. But a jury of 12 or a grand jury you're talking about?
Well, yeah, you got it pretty close. It's a body of 12 citizens. They meet in secret.
Have 9. Oh, excuse me.
That's right. They meet in secret. I just need to make sure you
Oh,
understand.
yes, sir.
And if 9 or more decide that there's probable cause, they return an indictment. If less than 9 believe there's probable cause, well, then a letter would go over the jail saying, release Mr. Simpson on this charge. You understand that?
Yes, sir.
Do you want to wait and see if a grand jury will indict you?
I'm good.
Or do you want to do this plea bargain?
Plea bargain.
All right. Well, then finally, Mr. Simpson, the last document I want to show you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document and sign the second?
Yes, sir.
And do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you read with Mr. Harrington?
No, sir.
Well, if you read and went over these with Mr. Harrington, I know that not only did he explain your rights to wait until an indictment is returned or if one is returned, I also know that he explained to you that you have many other constitutional rights, including the right to trial by jury.
Yes, sir.
Do you want a jury trial? Do you want to waive your right to a jury trial and enter into this plea bargain?
Yes, sir.
Then I'll ask you, sir, how do you plead to the lesser included offense of that which is charged in the information, the attempted tampering with physical evidence, convicted and punished as a Class A misdemeanor under 1244B of our penal code? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
I'll hear the evidence.
Thank you, Judge. State offers into evidence states 1 and states 2, the offense report and Morton discovery compliance.
No objection.
Submitted.
Further, rest and close.
Rest and close.
All right, then, Mr. Simpson, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that Class A misdemeanor under 1244B of our penal code of the attempted tampering with physical evidence as alleged in the information. The court will follow the plea bargain, sentences you to 76 days in the Henderson County Jail. However, you have credit for 76 days and orders you to pay your attorney's fees and court costs. And Mr. Simpson, did you have an opportunity to review the judgment in your case?
Yes, sir.
Was your name, the charge, and the time credit correct? Can
Yes,
you hand
sir.
that to Ronnie behind you?
Yes, sir.
And is he being held on anything else?
No, sir, I don't believe so.
Well, sir, I can't let you go from here. You got to go out process, but you're now remanded back to the sheriff for release from custody.
Appreciate you.
Yes, sir. You see Mr. Halbert to your right.
Thank you, Judge.
Mr. Simpson, see Mr. Halbert real quick.
Excuse, Judge.
Yes, sir. Thank you. We're working through. He's having issues going. Well, that's right. Has he tested positive on the other case before? Because the other case is not good. Yeah, Bill just needs to explain to him, no, I don't put him in jail. the first time. What do we do? Where's fault here?
She just texted me and said that her case still hasn't been filed and respond. So exactly.
Okay, see how far we get before we have to deal with it. Mr. Stevens.
Gerald Henderson, Your Honor.
Is that a plea?
It's a motion to withdraw, Your Honor.
I thought it was set for, oh, I see it. I don't know why I wrote plea. You got a plea on somebody else. Pearson.
I do have a plea for Mr. Pearson, Your
Okay,
Honor.
I wrote on the wrong.
Yes, sir.
All right, these are cause number CR 20-0, or just one, CR 20-0044-392, the state of Texas versus Gerald Henderson. And set for status and a motion to withdraw. So let's handle the motion to withdraw first.
Yes, sir.
It's your motion, Mr. Stevens.
It is, Your Honor. I'd advise the court that I hadn't seen my client in many months. He had failed to show up in court, so he recently got rearrested. I went to see him in jail. I guess it was maybe the end of last week. He refused to talk to me. He came out and was pretty rude, says, "You're not my lawyer. I'm not going to talk to you." I tried to talk to him about the case and he just turned around, put his back to me, and that was pretty much it. And he's always been unhappy with me for whatever reason, since day one. He's never liked me. And he's always said, "I'm going to hire a lawyer. I'm going to hire a lawyer." So I can't really represent somebody that refuses to talk to me and participate in his defense. So that's the basis of my motion, Your Honor.
Mr. Henderson, do you wish to be heard on this? Well, if you just yes or no, if you do, I got to swear you in, but I'm not gonna let anybody ask you anything about the offense, just about this relationship between you and Mr. Stevens.
Yes, I feel that Mr. Stevens
Okay, hold on. Can I get you to pull your mask down? And if you'll raise your right hand, sir. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, and again, I'm not gonna let him ask you about the offense you're charged with, just about this. So go ahead.
But I feel like Mr. Stevens never did anything to help me. I was in jail almost 6 months last year. I seen him 3 times. 2 times was he trying to coerce me to plead bargain for 10 years of penitentiary. I'm innocent in this case, and I explained that to him, but he has not did anything to help me. So I would like to have a new attorney.
Well, I mean, it sounds like you tried to talk to you the last time and you refused to talk to him.
Well, because he has not did anything. I'm back in jail now because he failed to mail me or call me about my court date in January of this year. I have not heard from him.
Let me see that document sheet. Thank you. Wow. So we mean, I'm trying to figure out what happened in January, why you weren't.
Well, I was told that a warrant was issued on me January 13th.
No, on January 13th, you were set for arraignment. When was that signed? I don't understand. I don't have all that. It's not on here. It's a re-indictment?
It must have been, Judge. My notes indicated that,
Re-indictment?
I think they're different years, 2020 years.
right.
Well, I got 20 here. Okay. All righty.
Judge, my notes indicated that he failed to appear October the 14th.
Yeah, I saw that. That's, a
That's what
lot
my
of,
notes indicate.
if you're failing to appear in court, then sometimes your attorney has a problem with you. And I'm looking through the docket and it showed that you had COVID, and appeared by Zoom once, and we're going to get proof of having the COVID and that kind of thing.
Yes, I understand what you're saying.
So, I mean, it takes two to tango, and it sounds like you weren't even present.
Well, like I said, Honor, that he has not did anything to help me prove that I'm innocent in this case.
You don't have to prove anything.
Well, I mean,
Mr. Henderson, you don't have to prove a dang thing. You could sit right there at council table all through your trial, and then every bit of that burden's on the state. And I'll make sure every bit of it's on the state.
yes, I understand.
And so here's what I'm gonna do. I'm gonna give y'all one more chance, to see if you can work it out. I'm gonna reset your status to June the 3rd, because let's face it, I have a responsibility to the taxpayers too. I mean, he's been appointed another lawyer, same thing might happen. So I'm denying the motion to withdraw at this time, resetting this for June the 3rd. And if y'all are still having problems, I'll be glad to take it up then.
Thank you.
Judge, will that be in the afternoon?
1:30.
All right, sir.
Somebody explain to him. Okay, so he's cool now.
Yeah.
I remember Mr. Cod. I think I prosecuted Mr. Cod at one point. All right, Pearson, is that the last one of the day?
It is, Judge, but we got one more piece of paper we filmed to get printed and signed. We'll do it.
Okay, now I'll wait because it's just that last, I think it's the last case.
We'll just take this stuff.
Okay. Well, Mr. Kaiser, we're waiting to go to the bathroom. Huh?
I supervised 2 years, he had the same conversation with explained.
All righty. This is cause number CR 20-0561-392, the state of Texas versus Christopher Pearson. And this is set for status today. However, a plea has been presented to the court. Is the state ready?
Yes, state's ready, Your Honor.
And on behalf of Mr. Pearson,
Defense is ready.
all right, sir, is your name Christopher Allen Pearson?
Christopher Aaron.
Christopher Aaron, I'm sorry. And are you the same person that was originally indicted by Henderson County Grand Jury for the third-degree felony offense of injury to a child, elderly, or disabled person?
Yes, sir.
I'll get you to raise your right hand the best you can, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Mr. Pearson, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Pearson, have you ever been treated for any mental health or emotional issues?
I'm not sure.
I mean, you're not.
I've been to hospital, but I'm not sure what they was, if it was for mental.
Okay, well, are you on any psychotropic medication?
I am on medication, sir, but I'm not sure what they are because I was just put on them right before I got locked up.
Who prescribed them?
It was a hospital up in Dallas.
Was it
It was
which hospital?
Presbyterian.
Was it for mental health or for physical health?
I was working on being put on into MHMR whenever I got locked up.
Okay. Have you been diagnosed with anything?
Not yet.
Do you understand what's going on in here?
Yes, sir.
Right, because, I mean, for the record, you
No,
seem
no, no.
articulate.
I'm good. I'm
Okay.
good. I was just going through evaluations.
Well, I have to ask you by law, I have to make a finding on your competency before I can allow you to plead. All right, and then Mr. Stevens, do you believe your client is competent?
Oh, yes, sir. Without a doubt, he is.
Okay, well, Mr. Pearson, the law presumes that you're competent, and even though you told me some things are going on, I have no reason to believe that you're not competent, so I'm going to find you competent.
Okay.
Mr. Pearson, I know you've already been arraigned on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom?
No, sir.
But do you understand the charge?
Yes, sir.
Well, as indicted, that charge is a third-degree felony. A third-degree felony carries a punishment range of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice, and a fine up to $10,000. Do you understand the range of punishment?
Yes, sir.
And the plea bargain?
Thank you, Judge. The agreement is the state is going to abandon the punishment enhancement in the indictment. This is a third-degree felony. The agreement on that third degree is 4 years TDC plus fees and court costs. And the state is asking the court to have an affirmative finding that there was family violence involved in this case.
All right. And is that your understanding of the plea bargain, Mr. Pearson?
Yes, sir.
And is that your understanding, Mr. Stevens?
Yes, Your Honor.
Well, Mr. Pearson, a few minutes ago, you told me you could read and write the English language. I'm going to show you 2 documents, the first of which is the agreed plea recommendation. Did you read and go over both the front and the back and sign them with Mr. Stevens?
Yes, sir.
The second document is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document?
Yes, sir.
Did you sign the back?
Yes, sir.
Any questions?
No, sir.
Any questions about any of the documents that you read and went over with Mr. Stevens?
No, sir.
Well, if you read and went over these with Mr. Stevens, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, sir.
Do you want to enter into this plea bargain?
Yes, sir.
Then I'll ask you, sir, how do you plead to the third-degree felony offense as alleged in the indictment? Guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
I hear the evidence.
Thank you, Judge. The state offers in the evidence states 1, states 2, and states 2. States 1 of the offense report. States 2 is Morton discovery compliance, and states 3 is supplemental Morton discovery compliance.
No objections.
Admitted.
Nothing further. Rest and close, Your Honor.
Defense rest and close. Ask the court to follow plea bargain agreement.
All right, then, Mr. Pearson, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that third-degree felony offense. As alleged in the indictment, the court grants the state's motion to abandon the enhancement paragraph, follows the plea bargain, sentences you to 4 years in the Texas Department of Criminal Justice, with credit for 282 days. The court makes an affirmative finding of family violence and orders you to pay your attorney's fees and court costs. And Mr. Pearson, a few more things I need to go over with you before you go. Did you have an opportunity to review the judgment in your case?
Yes, sir.
Was your name, the charge, and the time credit correct?
Yes, sir.
All right, sir. And finally, now that you've been convicted of this felony offense, you are now ineligible under Texas law to possess a firearm or ammunition. If you have any questions, consult an attorney. All right, good luck to you, sir. You need to see Mr. Halbert to your right. You're now remanded back to the custody of the sheriff, transport to the appropriate authorities to serve out your sentence.
Thank you, Judge. Might be excused.
Yes, sir.
Thank you, sir.
So he did not take the test. Mr. Kaiser, come on up. All right, we are back on the record in cause number CR 21-0324-392, the state of Texas versus DeMarcus Kaiser. Mr. Kaiser, the court, based upon the nature of your new charges, ordered you to take a drug test. Apparently, you could not produce a sample, but admitted that you had smoked marijuana just yesterday. Mr. Kaiser, I know marijuana is legal in a lot of other places, but it ain't legal here. And so I'm going to place you on conditions of bond, no alcohol, no THC in any form, no marijuana, no drugs not prescribed, and no illegal drugs. Okay, sir? All right. And so I'm going to give you written bond conditions. Once you receive those that are signed by me, you're free to go. I'll see you back on your next court date. But I'm going to test you again, more than likely, when you come in. And if you're positive, you may go out that door, not that one.
Yes, sir, it won't. It'll be sure.
I hope not. All righty. So if y'all get those to me and I'll sign them.
Yes, Your Honor.
Yep. That it?